Good afternoon, everyone. Welcome to the Senate Committee on Judiciary. We'll go ahead and get started. Will the Secretary please call the roll?
Senator Harris,
Here.
Senator Dondera Loop, Senator Orenshaw,
Here.
Senator Wynn, Senator Hansen,
Here.
Senator Krasner,
Here.
Senator Stone,
Here.
Chair Scheibel.
Will you please mark members present as they arrive? We're going to start by taking things a little out of order today, and I'll go ahead and open up the hearing on Senate Bill 411, which makes various changes related to services provided to persons with autism spectrum disorders, and invite our colleague Senator Orenshaw to the table. You can go ahead and begin when you're ready, sir.
Good afternoon, Vice Chair Harris, members of the Senate Judiciary Committee. For the record, my name is James Orenshaw. I represent State Senate District 21 down in Southern Nevada, and I appreciate your committee hearing Senate Bill 411 today. To my left, I have Judge Sonny Bailey from down in Clark County, and the reason I sponsored Senate Bill 411 has to do with a very amazing therapeutic diversion court that Judge Bailey initiated and fostered even prior to taking the bench when she served Clark County as a juvenile hearing master. And as most of you know, my day job is a deputy public defender in juvenile court, where I represent children who have gotten into trouble with the law. Many of those children themselves have been victims of abuse and neglect and had very tough upbringings that got them there. But one thing that Judge Bailey found was that there were many kids being arrested who either were on the autism spectrum or had been diagnosed or maybe had never been diagnosed and found themselves being arrested, being cited, and had never received treatment for what the treatment they need with the applied behavior analysis therapy, so much else. So she formed this specialty court down in Southern Nevada that tried to help these children get the treatment, get the therapy they need. Oftentimes, if the kids weren't diagnosed, she would work with community partners and arrange for children to get a neuropsych evaluation to try to see if they were on the spectrum. And so many of these children have benefited so much, and it's been a very collaborative effort with the district attorney, public defenders, private defense attorneys, juvenile probation, trying to get the kids the help they need, hopefully not end up in trouble again, not end up in the juvenile justice system. And they've had very excellent success rates. So it's something that she initiated that I don't believe we have in other parts of the state. And that's something that really affected me in working with Michelle Lewing of the Autism Coalition of Nevada and other stakeholders. We really asked ourselves, gosh, it's wonderful that Judge Bailey came up with this idea in Southern Nevada. It'd be so great if kids around the state who are on the autism spectrum, who maybe have been diagnosed, maybe have not been diagnosed, could be eligible for this kind of help if they get arrested, if they find themselves in juvenile delinquency court. So that's the bill in a nutshell. There is a section that deals at the end with the Commission on Autism Spectrum Disorders that tries to solve a little problem that the Commission was having with quorum. But the heart of the bill has to do with trying to see this therapeutic diversion court for children on the autism spectrum become something that isn't just a help to children in Clark County, but is a help to children across the state. And with your permission, Vice Chair Harris, if I could turn it over to Judge Bailey, then I'm happy to answer any questions the committee members have. Thank you.
Good afternoon. Thank you for having me. For the record, I am Sonny Bailey, and it's Soonhee, but I go by Sonny, like the weather. Bailey, Bailey. And I am a judge for the 8th Judicial District Court in Clark County, Nevada, and I serve in the Family Division. And I've been appointed for, actually been assigned to the juvenile delinquency portion of the family court. Just to give a little bit of background, the CDC estimates that 1 in 36 children have been diagnosed with autism spectrum disorder. And we do use the term neurodivergent, but I'm going to use autism spectrum disorder because that's the specific aspect of the bill. And there was an amendment, so hopefully everyone has the amendment. The thing about autism is it doesn't discriminate against race, ethnicity, or any socioeconomic group. But it is nearly 4 times more common in boys than girls. Youth with ASD often display inappropriate behaviors in various situations, And when we try to determine why someone with ASD has these inappropriate behaviors, we often look to what we call the function of those behaviors. Is it attention seeking? Are they trying to get access to something, escape avoidance, or is it to seek sensory? Although aggression is not a symptom of autism, youth with autism sometimes behave aggressively towards themselves or to other people. This can lead to charges for battery on protected persons, battery, domestic violence, threats to cause bodily injury, as well as other charges in our criminal justice system. Additionally, these behaviors create dangerous situations for the family members, other students at school, teachers, first responders, medical personnel, and the public in general. SB 411 allows the juvenile justice system to create a program to address the needs for these youth. There is a program that already exists in Clark County, Nevada, and it has existed since 2018. We call it the Detention Alternative for Autistic Youth, the Day Court. And it is a program for youth involved in the juvenile justice system with a primary diagnosis of autism. It is the only program of its kind in the entire country. The goal and function of Day Court is simply put to increase skills and appropriate behaviors in youth with autism. As the appropriate skills and behavior increase, the excess behaviors will decrease. And the program's designed to address the lack of services and to implement the proper programs and services to prevent future illegal behaviors, especially aggressive, violent behaviors. Almost all of the youth in the program that come in, they don't have any services to address their needs. Many don't even have a diagnosis of autism. Often parents are told that their children have behavioral problems, but they're not told how to address them. Often what they have is they go to emergency services and they're seeking residential treatment centers. But what they're told is they're given diagnoses such as ADHD, ODD, OCD, conduct disorder, bipolar, anxiety, and PTSD. But they're not told how to handle these behaviors, and medication isn't the solution. And we often have youth with all those diagnoses that come into our delinquency system. On such occasions, we have our team that we staff the youth and will often arrange for a neuropsychological evaluation to completely rule out whether or not the youth is on the spectrum. Since the inception of Day Court, approximately 65% of those neuropsychs have resulted in an ASD diagnosis. This also includes youth who have charges for juvenile sex offense, that the offense is actually a result of their autism spectrum disorder and not actually a deviant behavior. Once a formal diagnosis is obtained, or if the youth has a formal diagnosis, the team then begins the process of obtaining the necessary services for that youth. And currently, Day Court is made up of a DA, a PD, and probation, and community partners who all volunteer their valuable time to ensure the success of this program. Each person who volunteers for this program, they do it in addition to all of their other duties. They don't have any breaks or anything to do this. And I'd like to say that Day Court was formed in a very organized fashion, and we had everything all outlined. It wasn't. It was accidentally formed one day when we had an autistic youth come through detention. And on a Thursday afternoon, we set a special calendar so that youth was not going to be overstimulated. The next thing we know, probation came in and said, we have an autistic calendar for these youth. And we said, we didn't have a special calendar for them. But we had one set aside for that particular one. The next thing we know, we had 2 youth on that calendar. And then someone showed up and said, we heard you had a calendar, I want to help out. We said, well, we don't have a special calendar. We had it once a month then. And then someone else said, well, my friend said you have the special autism court, so now I want to come volunteer and help out. And the next thing you know, we had more people showing up. And I kind of always remember that hair commercial from the 70s, and they told 2 friends, and they told 2 friends. And the next thing you know, we had more volunteers and more volunteers that showed up saying, we want to be part of this court because we want to help out. We want to help these youth obtain these services. As of now, the volunteers that we have include representatives from the Autism Assistance, ATAP, Autism Treatment Assistance Program, where they send a representative where we can get them the actual applications and they can shortcut our families into their programs to help them get the services they need. DRC sends a representative so that we can get them into a case manager. Legal aid send somebody so that they can look at the IEPs to make sure they appropriately address the behaviors. So that way these youth aren't getting expelled for behaviors that should be addressed because of their function of their autism. Project Mind sends someone, they're an ABA provider. The ABA group sends a BCBA who volunteers his time every week to address behaviors, because we now meet weekly. Families for Effective Autism Treatment not only sends someone to volunteer, they give us scholarships to allow for social programs. The Collaboration Center recently had this arranged for the Smith Center to give us 20 tickets so that youth who are dual ward that were in foster care could go and attend the sensory-friendly program for Frozen. The Ackerman Center helps us with assessments, as well as Dr. Davis. Sports, Social, and Inclusion Fusion and Hard Knocks helps us with social programs. Behavioral Essentials, Moving Mountains, Lovaas Center for Behavioral Intervention helps with parent training and ABA services. DFS, CAP attorneys, and CASA help with our dual wards. We look like the Muppet Show every week on our Blue Jeans link. The end goal for all our participants is to obtain applied behavioral analysis services for the youth before they turn 18. If we don't get them diagnosed and in an ABA program prior to the age of 18, the likelihood of them qualifying for a program is almost none. ABA can help increase communication skills, social skills, and decrease problem behaviors, just to name a few of the positive outlooks. When I describe ABA and the positive things that we look at, it adopts the Skinner method of behavioral modifications through reinforcement. When I describe it, I always talk about the Big Bang Theory. There's an episode where Sheldon wants to try to get Penny to be quiet during one of his favorite episodes. So whenever she's quiet, he always gives her a piece of chocolate. And that's positive reinforcement. That's what we do for day court. We actually use chips. The kids love chips. But it works very well. And we teach the parents the skill because the parents have been reinforcing the wrong behaviors. So we're retraining the parents and we're retraining the kids that these youth can be trained to and modify their behavior to decrease those aggressive behaviors that they have. ABA has been successful, and it's been shown to be incredibly successful for these youth on the spectrum. And my personal experience with ABA is why I'm such a huge advocate of it. I know about ABA because I have a youth who's now almost turning 25 on the spectrum. I moved to Nevada to get this program, and this program has changed my life. I sit before you because of this program. My family is thankful for this program. Prior to moving to Nevada, my daughter had over 250 aggressive episodes per day of aggression. After having ABA, which we participated in for over 15 years, so I'm a trained behaviorist, she's down to about one every 4 months or so, and it's nothing. But like I said, without that program, we were actually told when she was 5 that she was so aggressive that they felt she was going to kill me at some point. We've had broken bones. I've had 4 herniated discs in my neck, dislocated fingers, my foot has been broken. She's broken every finger and every toe, as well as her nose. So I know the benefits of ABA and what it can do for families. And I sit before you having a career because of it and able to function. And I know that we do that for the other families that participate in our program. And one of the reasons why we feel so strongly about being involved in the juvenile justice system with the day court is because we don't know how many youth in our juvenile justice system are on the spectrum. There's no numbers. And especially since even with our testing, 65% have come back on the spectrum, we have no idea who's undiagnosed. It's even more difficult to gauge how many adults are in the criminal justice system or in the prison system with ASD. A 2012 study of 431 prisoners found 4.4% with ASD prevalence, double those in the general population. And many of those are, there's even more that are undiagnosed. More recently, it was estimated that this number could be as many as 100,000 adults in the U.S. prison system currently with autism. Many states are currently attempting to address the issues of those adults with ASD in the prison system. However, that's a little too late. SB 411 aims to prevent them from ever getting there. The success of the program of day court speaks for itself. Since 2018, we have graduated 65 youth. We've had 5 youth come back. Of those 5, only 1 had stayed in the ABA program. So, and none of them were sex offender programs. We had 0 recidivism for the juvenile sex offender cases. In closing, I want to thank you for your time. I know that when you're here in legislative session, I've watched some of your sessions, you hear a lot of complaints. I wouldn't want your job. And, we hear about what Nevada doesn't have. Everyone's talking about what we don't have. But what I'd like to highlight is what we do have. And what we do have, and what I've personally witnessed again and again, is that we have strength, resiliency, and a commitment to our community and our residents. And we just flat out care about ourselves. I mean, we care about our community and we care about our kids. And so I'm here today to request that you take this opportunity to show the rest of the nation that we as Nevadans, what we already know, we care about our youth, and by passing SB 411, we'll become the first state in the nation to actually recognize a juvenile justice program for youth, to allow them to divert out of the criminal justice system. So I'm asking that you pass SB 411. Thank you.
James Orenshaw, Senate District 21, Chair Scheibel, members of the committee. I can't stress, if you ever have time to come down and view the Detention Alternatives for Autistic Youth Court, how you'll see a group of people who all care so much. Prosecutor, defense attorney, probation officer, and all the stakeholders trying to see these kids succeed, get the help they need, and hopefully not end up back in the system. Judge mentioned DRC, Desert Regional Center. That's a division of the state of Nevada where if children, as they progress into their adult years, need assistance into their adult years, they can get that through Desert Regional Center. And them being there at the autism court cuts through a lot of red tape in terms of kids getting that help. Although I think that most kids who go through Judge Bailey's program eventually are able to live their lives independently and don't need that help. But Desert Regional Center is there for kids who do. With that, I'm happy to answer any questions, and thank you, Judge Bailey, for being here.
Thank you both for that presentation. Apologies for my tardiness, but I did catch most of the hearing, and I'm sure we have some questions from members, starting with Vice Chair Harris.
Thank you, Chair Scheibel. I'm looking at Section 1, Subsection 1, Paragraph C, where it says is not ineligible for assignment to the program pursuant to any other provision of law. Do you all know what might make someone ineligible to participate in this program? Many provisions of law.
This is Judge Bailey. So far, we've been able to accept anyone who has an autism diagnosis.
So I guess the question would be, what is the purpose of C? Right? Who are we trying to keep out?
And James Orenshaw, State Senate District 21. I believe that was put into the statute, or the proposal here for the bill, so that if there is perhaps a child where either they're subject to perhaps a certification hearing where the state is seeking to certify the child as an adult, then I don't believe the program would be available to that child. This would be limited, and there may be other instances I'm not thinking of, but that's one that comes to mind right now. I'll turn it over to Judge Bailey.
And this is Judge Bailey. It was there in case there's any, if there may be a direct file or someone who may not be, they may not end up in our juvenile system, or just in case if it's a caveat, catch-all.
Okay, so are there, so throughout the NRS, there are certain sections that say if you're charged with this or under this scenario, direct file or whatever it may be, you are not eligible for any type of diversion program?
And this is Judge Bailey. We would lose jurisdiction over the youth at that time.
Okay. All right, thank you.
Other questions? Senator Stone.
Senator Orenshaw, thank you for the presentation, and Judge Bailey, it's an honor to meet you, and I really appreciate this program. I did know it existed. Just so you know, my oldest son, his name is Jason Stone, former DA. He's now a Superior Court judge in Riverside County, and he is the parent to my oldest grandchild. Her name is Luca Stone, who is a severely autistic young lady, right? And so you resonate with me, and I've already texted my son. I said, if you don't have this kind of a program in Riverside County, you better consider adopting it. So But I want to just share with the committee, if I could, if you haven't had close contact with a severely disabled or autistic child, one, you just love them more. I mean, I'm crazy about my granddaughter. She's nonverbal. But as many know that deal with autistic children, is that they're very sensory sensitive, right? So one of the challenges that my son has with his daughter, my granddaughter, is that when she comes home from school, the first thing she wants to do is take her clothes off, right? And so I'm sure that you probably see autistic children that are brought in for indecent exposure. It's not because they're getting a sexual thrill out of exposing themselves, it's because it's a sensory release for them to take their clothes off, and diverting them into a program that can help with them with their behavioral health. And of course, it would be criminal to put them through the criminal justice system, to me is exemplary of a very compassionate and caring state, when most states don't have effective, comprehensive services for autistic children. So I want to thank you, Senator Orenshaw, for bringing this forward. This is a magnificent program. And to you, Judge Bailey, I can't thank you enough. And I hope that maybe we can talk off record, and I would like to connect you with my son, because this is something, we need to replicate this not only throughout Nevada, but throughout this country. And I really appreciate you being here today.
Thank you, James Orenshaw, Senate 21. Through you, Chair, to Senator Stone, thank you for your kind comments. And I hope that we'll see therapeutic diversion courts like this throughout the state and throughout the nation, because I think that, just as you said, it would be criminal to put a child on the spectrum through the criminal justice system. I think that there's so much more that can be done, and we're seeing that in Clark County through Judge Bailey's work and through everybody else who's partnered with her on this.
Other questions from members of the committee? I just have one, and you may have addressed this, but I noticed that in Section 1, Subsection 1, it is a shall as opposed to a may. And so are you expecting that other jurisdictions will develop these courts, utilize Clark counties, or something else?
And this is Judge Bailey. There's an amendment where it's corrected to may. And we're well aware that it should be more discretionary. Thank you for bringing that up.
Thank you, Chair. And James Orenshaw, Senate 21. I think I neglected to appoint committee members to the amendment that is on Nellis being proposed by Mr. Moses, and I appreciate all the stakeholders working with me. The shall becomes a may in that amendment, and there's some other changes in consultation with District Attorneys Association, some other groups, just try to make sure that we provide this framework, and hopefully we'll see it in all the different judicial districts and counties. But in consultation with all the stakeholders, there shall is a may on the amendment.
And I do see that amendment now that I have looked, I took 3 more seconds to look at Nellis and click on the proper link. So thank you for anticipating my question and addressing it so thoroughly. Unless there are any other questions from members of the committee, thank you for your presentation. We'll move to testimony in support of SB 411. Anybody wishing to give support in person is invited to the tables in Clark County, Las Vegas, Clark County, or in Carson City. I am going to have to limit you to 2 minutes apiece because we have a lot to get through today. So go ahead whenever you're ready here in Carson City.
Afternoon, Chair Scheibel. My name is John Abel. I'm the Government Affairs Director for the LVPPA. We're the union that represents the Metro officers rank and file. So before I was union rep, I was a patrol officer for most of my career. I have had interactions with autistic children. Some have been violent. Luckily, I've never had to use force. And one thing that a lot of my mentors outside of law enforcement have taught me is that you can't police your way out of every problem. And the last thing that we want to do is have these kids be in this revolving door of getting arrested, going to jail, going to court, back home, and their parents do not know how to deal with them. So programs like this limit the interactions that law enforcement have with them, because I know a lot of my law enforcement brothers and sisters have had to use force on children, and it's terrible. So programs like this help to keep them out of our hands and to get them the help that they need. So for that reason, please, we ask that you pass this bill. Thank you.
Good afternoon, Chair Scheibel and members of the committee. I'm Assistant District Attorney Bridget Duffy, Brigid, I am appearing on behalf of the Nevada District Attorneys Association in support of SB 411. My attorneys in Clark County, they actually person the autism court. I have attorneys that go in there, and this court, this specialty court, I can't really emphasize enough the difference that I have seen Judge Bailey make in the lives of children with autism that have been in this revolving door of going into juvenile detention and coming out. They don't usually stay in juvenile detention for very long, but there's one particular case of a child that we were just not knowing what we were able to do with. There was a lack of services in our community for children that have autism, and this child kept lashing out and hurting other people. And that child has been so successful since being placed into this program. We have not had any occurrences, and I directly say that's because of Judge Bailey. So thank you very much for your consideration, and we support SB 411.
Chair, members of the committee, Jonathan Norman with the Nevada Coalition of Legal Service Providers. I had the pleasure of working in Judge Bailey's court as the legal aid representative in day court. And, you know, it's a wonderful chaos there because how it works is all these community providers are present and Judge Bailey's assessing and the clinical assessing what that kid needs. And literally it'll be like, what's going on with this kid's IEP? And the parents have an answer. They're like, we don't know. And she's like, you need legal aid. And the referral's made right there. So there's no referral where somebody has to show up to our office. We're getting the contact information in that moment, and we're able to reach out and bring them in as a client so we can make sure the IEP's dialed in. And that's how it is for all those service providers that are present. So it really cuts through a lot of red tape for the most vulnerable kids in our community. And so I'd like to thank Judge Bailey for being a tireless advocate for kids in our community, and Senator Orenshaw for bringing this bill. And then just, you know, the power of ABA therapy for those kids, it is a game changer. Like, I've seen kids go from not able to take care of basic hygiene to, in 6 months of intensive ABA, to doing chores, able to cross the street and buy a soda and get proper change. And so I can't speak highly enough for the work that they're doing and the power of ABA for those kids. So thank you.
Bailey Unruh, a representative for the Autism Coalition of Nevada, and I'm here to share our group's collective support for this, SB 411. Day court is truly one of the most incredible things that have ever happened to families in Nevada. Due to the nature of autism, it's that some individuals on the spectrum have severe fight or flight response that is no fault of their own. Many of these individuals will react in fear and flail their arms or sometimes even strike out in terror. These are not premeditated behaviors, and the individuals may not realize that their actions are wrong or even question that after the fact. They have no control over their responses. The amygdala, the fight or flight center of the brain, is scientifically proven to be inflamed in brains of people with autism. Dr. Temple Grandin said it, my fear is the main emotion of my autism. My amygdala is 3 times larger than anyone else's. She's one of the most famous autistic individuals in the world. We get so many calls from all over the state from parents of autistic children who have entered the court system due to a situation where they may have struck out in fear, which is interpreted as violence or anger. These kids end up in juvenile detention, which is a sad situation, and it's terrible for those because they're just clearly misunderstood. The day court is vital to keeping kids out of the the detention system, and gives them a chance at getting therapy and care that they need. Please help support this bill, and we're very thankful for Judge Bailey and her work.
Good afternoon, Chair, members of the committee. Erica Roth on behalf of the Washoe County Public Defender's Office, testifying in support. This bill is an opportunity for Nevada to be a leader in therapeutic diversion courts, and we urge your support. Thank you.
Thank you, Chair. John Pure from the Clark County Public Defender's Office. We'd like to thank Senator Orenshaw and Judge Bailey for bringing forward SB 411. This bill provides a pathway for treatment for our neurodivergent children who have been brought into the juvenile justice system. I do wish that the bill would have kept Section 1, Sub 2, Sub C. I think if a whole family works their way through a program that's like intense and they're going through it, I think the child should get a dismissal at the end. But I still support the bill nonetheless. Thank you.
Barry Cole, Barrycole, psychiatrist, and I am totally impressed with this bill because it takes a block of patients for whom we have very poor resources in psychiatry and comes up with a functional way to manage them. If you're not familiar with the term Skinnerian, you should know it by its other name, operant behavioral. This is the most elegant form of behavioral modification that we've ever had, and in fact, it's used routinely for the management of people with chronic pain. That's how we get people off opioids. That's how we get them restored, hopefully, to gainful employment with operant behavioral techniques. It's the opposite of a guy named Pavlov ringing bells to get dogs to salivate. That was classical respondent behavioral modification. So this is a very elegant application of one of our most effective forms of behavioral modification. I'm very excited about SB 411, and I hope you are as well.
Chair Scheibel and Senate Committee on Judiciary, my name is Chris Reese. It's R-I-E-S. Just be brief, we support SB 411 on behalf of the police department. Thank you.
All right, looks like we have somebody to give support testimony in Las Vegas. Please go ahead.
Thank you. Julia Ostrovsky, Juliostrovsky. I'm a former commissioner on the Commission on Autism Spectrum Disorders and currently a parent of a 25-year-old who had the opportunity to have ABA beginning at a young age. I support SB 411. What I have witnessed through the remarkable efforts and passion of Judge Bailey and all the volunteers that work with her, it changes lives. It makes our community safer and a better place to live. Undiagnosed autism is not a crime, but rather an unfortunate circumstance. By identifying what's causing criminal or violent behaviors and then offering the opportunity to intervene and change those behaviors is life-changing and life-saving. Intervention over incarceration is the most ethical thing to do. It is the right thing to do. And having the opportunity to evaluate the accused in our court system, it's just remarkable. I'd also like to address the boards and commissions. The Commission on Autism Spectrum Disorders has always been an incredibly strong commission, and I'm sure if it were still working and running right now, it would support efforts like Judge Bailey's. Unfortunately, when the commission was started and put into statute in 2019, the school districts were offered the opportunity to appoint commissioners. In the end, they were unable to vote representing their school districts, outstanding advisors, but couldn't vote. Therefore, the commission could never make a quorum. It's an important commission because programs like Judge Bailey's and others throughout the state deserve to be recognized, supported, and created. So I support SB 411 because everything in this bill is remarkable. Thank you.
Thank you so much for your testimony. I don't see anybody else in person to give support testimony on SB 411, so we'll go to the phones, please.
Thank you, Chair. If you would like to testify in support of SB 411, please press star 9 to take your place in the queue.
Good afternoon, Madam Chair and members of the committee. Stephen Cohen for the record. Stephen with a V. Cohen is in the Assemblywoman, no known relation. Ditto. Thank you, and I yield.
Hello, my name is William Ledford, Ledford. I'm the Director of Advocacy for Lutheran Engagement and Advocacy in Nevada. Ditto all of the amazing testimony so far. We don't have justice unless there's justice for all, and this is a fantastic step in that direction, so we're excited to support this bill. Thank you.
That concludes callers testifying in support.
All right, we'll move to testimony in opposition. Anybody wishing to give opposition testimony in person is invited to the seats in the front of the room in Las Vegas and Carson City. But I don't see anybody, so we'll go to the phones for testimony in opposition to SB 411.
If you would like to testify in opposition of SB 411, please press star 9 to take your place in the queue. We have no callers to testify in opposition.
Okay, then we will move to neutral testimony. If there's anybody wishing to give neutral testimony in person, now is the time to come up to the table. But I don't see anybody, so, oh wait. Nope, okay. Just someone switching seats. We will go to the phones for testimony in neutral on SB 411.
If you would like to testify in neutral for SB 411, please press star 9 to take your place in the queue. We have no callers to testify in neutral at this time.
All right, then that brings us to the conclusion of our testimony. I'll invite the sponsor back up for any closing remarks.
Chair James Orchall, Senate District 21 committee members, thank you for hearing this bill. I appreciate you taking the time. I know the schedules are so busy now towards the end of session. I think this definitely can help so many kids. I'd really like to see it statewide. With your permission, Chair, if I could turn it over to Judge Bailey to make a brief closing comment.
And this is Judge Bailey. I just want to thank you again for your time and your dedication to the youth of Nevada. And again, I'll give your son my number as well. And just thank you again on behalf of our youth, and just urge you again to pass SB 411. Thank you.
All right, I will now close the hearing on SB 411. That takes us into our work session. And to start this work session, I would entertain a motion to amend and do pass SB 411.
I'd so move.
All right, we have a motion from Senator Wynn. We have a second from Senator Stone. Is there any discussion on the motion? All right, seeing no discussion, all in favor say aye. Aye. Anybody opposed, nay. That was a resounding unanimous vote to amend and do pass SB 411. I will assign the floor statement to Senator Orenshaw.
Thank you, Chair. Thank you, members.
And that takes us to the next bill on our work session, and Mr. Guinan will tell you what it is.
All right. Excuse me. Thanks, Chair. The first bill on the work session today is Senate Bill 235, which is a bill relating to pretrial release. This is a committee bill that comes out of a recommendation from the interim Judiciary Committee. We heard it here on March 24th. Senate Bill 235 authorizes a court to extend a pretrial release hearing at the request of either party or the court for good cause shown. It also allows an extension upon the stipulation of both parties, prescribes in what manner such a stipulation may be made, and prescribes when a continued trial must be rescheduled. There's an amendment that Senator Harris proposed that is attached for your review. It adds a new Section 2 to allow a court to impose additional conditions of release if a person fails to comply with release conditions. And that's all I have, Chair.
All right, are there any questions about SB 235? All right, I would accept a motion to amend and do pass.
I'd so move.
All right, we have a motion from Senator Wynn, a second from Vice Chair Harris. Any discussion on the motion? Senator Stone.
Thank you, Madam Chair. I think I'm almost there in support of this. I know that there was some opposition by the District Attorneys Association. I think are still working with the author. And so I'd like to vote yes today with the reservation that I can change my vote if necessary, but I plan to vote yes today. Thank you.
Understood. Thank you. Oh, Senator Krasner.
Thank you, Chair. I spoke with Assistant District Attorney John Jones just a few minutes before this, and he said he was working with you on an amendment to exempt 4 holidays. How's that coming along?
We are still talking about the possibility of making additional amendments to the bill. And at this point, we haven't come to an agreement, but, you know, I'm hoping that we can still move the language that we do have. All right. With that being said, all in favor say aye. Aye. Anybody opposed, nay. All right. The motion carries to amend and to pass SB 235. And is there a volunteer for the floor statement? Senator Orenshaw.
All right, we are now at Senate Bill 296, which is a bill sponsored by Senator Harris related to traffic stops. We heard this bill on April 12th, just the other day. It prohibits a peace officer from stopping a vehicle for the sole purpose of determining if the driver is committing a low-level traffic violation or to issue a citation for a low-level traffic violation, which includes some violations related to registration, license plates, permits for unregistered vehicles, and some speeding violations. Any evidence acquired during such a stop is not admissible in court or other proceedings, and law enforcement agencies are required to adopt written policies to comply with these provisions, which must require that violations that threaten public safety be prioritized over low-level violations. Senator Harris has proposed an amendment that was offered at the initial hearing on the bill. It's attached for your review. It limits the provisions of the bill to prohibit a peace officer from issuing a citation for certain violations relating to registration, license plates, permits for unregistered vehicles and equipment, unless the violation is discovered when the vehicle is halted or its driver is arrested for another alleged violation or offense. That's it, Chair.
Thank you. Any questions on SB 296 or the amendments? Senator Dondero Loop.
Madam Chair, I appreciate the work on this bill, but I'm not quite there, so I'll need to be a no for today.
Understood. Senator Stone.
Thank you, Madam Chair. And I just want to say that I have tremendous respect for the author and what she's trying to accomplish. And I've been the victim of this kind of activity. My hometown was Temecula, California, which gets up to about 112, 114 during the day. We have a lot of sun like Southern Nevada does, and I got a ticket for having tinted glass on my car so that I didn't get blinded by the sun, and it kept my car kind of cool. But my concern with this bill is that we empower our police departments to follow the law and to cite people. And if we don't want them to cite people, then I think we need to go back to the law and make provisions in statute so we are very clear with our law enforcement as to what they should be doing and maybe what they shouldn't be doing. So, but I also want to just mention one thing that happened while I was a county supervisor in Riverside County. We had an employee, his name was William Suff, and you can Google him, S-U-F-F. He was pulled over for one of these random stops, and he was then arrested, and he was later convicted of being Riverside, actually, I think one of the state of California's largest serial killers. He was referred to as the Riverside rapist killer, murdering over 20 women. So there is some utility to these stops, but I understand where the author is coming from, but I think we ought to go back to the statutes and relieve the officers of performing these tasks if we're going to move forward with something like this. And so I have to be a no today. Thank you.
All right. Senator Hansen.
Actually, we haven't had the process. We're discussing the bill a little early, but I'm supporting the bill. I think the intent is correct. I agree with Senator Stone. One of the officers came up and he said, look, you guys pass all these laws and then you restrict our ability to enforce the law, and I have complete sympathy with that. I do notice, though, in the amendment, they still have the ability to pull over for warnings. Really, all you're doing is stopping their ability to issue a citation, because as we've learned, a lot of these seemingly not significant stops often evolve into something where they find significant things, as Senator Stone just mentioned. But nevertheless, I very much are going to support the concept of you need to have some level of probable cause before you start stopping people looking towards criminal citations. The one question I never got answered, though, is, and maybe with legal and Senator Wynn here, is this still under, since we've decriminalized the traffic citations, is this particular type of citation still considered criminal in nature, or is it now whatever traffic citations are considered?
So I can answer part of that question. The registration is still a criminal violation, but the taillights would be a civil violation. So the lawyerly answer is, it depends.
Okay, so it's split.
So-
No, I was just curious because we have been trying to decriminalize traffic stuff, and so I thought it would probably fall into that. Anyway, I support the bill. I do think the law enforcement community's got a legitimate concern, though, because we do give them the assignment of enforcing laws, but then we kind of tie their hands on certain ones, and I can see their rising level of frustration. If we're going to pass a law like this, we should probably also pass something that essentially removes headlights and taillights and things like that from any criminal possible parts of the law. So anyway, I support it. Thanks, Madam Chair.
All right. Anybody else have questions, comments on this bill? Or I would accept a motion to amend and do pass. All right. I have a motion from Senator Orenshaw and a second from Senator Wynn. All in favor, aye. Aye. All opposed, nay. All right. So the nays are Senator Don Darrow Loop and Senator Stone. Did I get that right? Okay. The motion does carry, and I will assign the floor statement to Senator Harris.
Okay.
Do the first part and I'll do the amendment.
Okay, and also. Okay, next bill we have up is Senate Bill 307, which is sponsored by Senator Spearman. This is also one we heard on April 12th. It relates to human rights and solitary confinement. I'm just going to go through the summary. There is an amendment that the chair has graciously offered to discuss with the committee. SB 307 requires the director of NDOC to adopt regulations ensuring that solitary confinement may only be used as a last resort when the offender must be separated from the general population in a secure environment in the least restrictive manner and for the shortest time possible. The bill requires the adoption of regulations prohibiting the use of disciplinary segregation for vulnerable offenders with serious mental illness or mental impairment, and provides for review and evaluation of solitary confinement, access to programming for offenders in solitary confinement, training for staff who work in solitary confinement units, and other minimum requirements, reviews, and other procedures relating to solitary confinement. And the bill lastly limits the maximum number of consecutive days that an offender may be assigned to solitary confinement to 15 days. And the amendment, just to be clear, comes from Senator Spearman and is in concert with some other folks. I think some of them are here, Chair, if you would need them.
Thank you, Mr. Guinan. Yes, we just heard this bill yesterday. I think that the only hesitation we had on it was that the director of the department, Dr. Zarenda, explained to us that there were some provisions missing in the amendments. Those provisions have been added. I believe it is section 14 and section 15 that address the concerns with having for clinical interventions and for other special cases. And Director Zarenda is here if any of you have any questions on the bill or the amendments. Yeah. It looks like you've been invited to the table, Director Zarenda. And we'll start with Senator Hansen.
I actually had to step out, and I didn't get to hear your testimony yesterday. Obviously, we were up against the clock, so, I would have swung back around, hopefully, and talked to you. I did have a fascinating conversation with Karen Gedney, who was the one that testified and been in the prison system for 30 years. She's even written a book. I actually ordered it on Amazon today because her experience is so good. So I talked to her at length about it. Because I didn't hear yours, though, I was actually going to vote no on this bill, mainly because there's a lack of balance in this, it seemed to me, and I just thought we're rushing something that is really pretty significant. So, but now what's your take?
Sure. James Renda, for the record, Director of the Nevada Department of Corrections. So there were some concerns of mine, but the issues that I had were around solitary confinement where it's not black and white. When you have offenders that will not tell you why they misbehave, there's some offenders, and like I said in the testimony, it's not hypothetical. We have a lot of situations where offenders come in that had violence on the streets, that could have killed a gang member on the street. Now their lives are in danger. They don't want to tell us because they don't want to be identified as a snitch. which is a slang word for someone that's a tattletale or reported someone. So they result to violence to be able to be separated from the other offenders. It's hard for us to try to find the root of those things. When those offenders get into solitary confinement, even when their time is up and they get released back, they refuse. They also result to threatening or violent behavior so they can stay in. Those behaviors are like that with them, with that type of individual, because it's a way for them to say, I'm in here in solitary confinement because I'm violent, not because I'm scared, or not because my life's in the line. So you have issues like that that I thought needed to be addressed, that we're not just forcing individuals off in the bill as it was originally written. We'd have to force individuals off of segregation status after 15 days. Well, there's certain situations, we force someone off, we're going to be in trouble. Either that individual's life's going to be on the line or someone else's is. So there has to be a system in place to go at what is the root of the issue that's around it, to be able to determine whether or not there's other options. But right now, it does correct that in there, so it gives us those options. There's also other individuals, clinical advises many times. It's not hypothetical, like I said, of individuals, I don't know, they could be paranoid schizophrenia, they could be someone that's maybe should be on psychotropic medication that's either refusing or not, or who knows what the issues are, but they have in their minds either antisocial behaviors that are afraid to come out near anybody else. They threaten to say that if you're letting me out, I'm going to either assault you, stab somebody so I can get back in there. We also have something, believe it or not, that some clinicians identify as homicidal behavior. If I force individuals out of 15 days to come into population when a clinician told me they're homicidal, we're in trouble. So there are things like that that I knew had to be addressed in there, where clinical can actually make a recommendation to remain on segregation past or solitary past 15 days. However, there should be a piece where there's, what do you do about it? And that's where I think it had to be added also into the bill, which is, have some type of intervention being done. Has to have some disciplinary team that involves mental health, involves custody, the officers, that really look at the root of these issues of why they would be refusing or why would they threaten when they come out of here. You don't want to push those people into population and then you're having a worse problem that coming in. So I think those were all addressed in the amendment since yesterday. And then accountability of it, I saw the amendment on the reporting of it. I'm okay with reporting every time someone refuses, where it goes, and have a tracking of it so that we understand how many of these events actually happen, and what we're doing about it, and how long it goes past those 15 days of why they're still in there, what's happening, and what's the next step.
All right, well, basically you're Caesar, so it's this or this, so you're saying this, so I'm going to vote for the bill. I do want to say I want to get on the record. Been watching Department of Corrections for a long time, 7 sessions now. You've been a tremendous breath of fresh air. I was so disappointed when you left, so I'm glad to get you back. However, since on this committee we also have the Chair of Finance, one of the biggest issues that we've had is you guys, we expect miracles out of you, and then you're always underfunded, and there's a lack of staffing, and there's a lack of financial, all this stuff takes resources, and we demand all these services from you, but then we don't provide the resources to get it done right, and then we're mad when things don't work out the way we in this room would love to see them happen. So I want to get a little plug in there that, hopefully the Department of Corrections can get a few extra bucks to do some of these things, especially the stuff that Dr. Gedney described to me after 30 years in the system. I'm looking forward to reading her book. Thank you, Madam Chair, for this indulgence. Thank you so much for your work on behalf of the unfortunate people that are in the prison systems in Nevada.
I don't think you're off the hook just yet. Senator Stone has a question as well.
Thank you, Mr. Director. And I haven't been in Nevada very long, but I have to say I've worked with a number of wardens before and a large criminal justice system in another state. And I have to say that you are a breath of fresh air, and I really appreciate that you're here and working with the limited resources that you have. And I appreciate that you are here to again address this issue, and I want to applaud the author who I met with this morning and thanked her for illuminating the details of solitary confinement and making the process more transparent and not torturous, if you will. So you remember we had some conversations. I asked you if we had certain healthcare professionals that were required by this bill to be intervened, if you will. I think it was like almost every 15 days to assess the health of the inmate. And you made it very clear that you don't routinely hire this cadre of healthcare professionals. So how did you mitigate that, or have you mitigated it yet? And are you able to use telehealth to make sure that these people are getting the appropriate oversight to make sure that they're not suffering any physical ailments as a result of their incarceration?
So James Miranda for the record, and thank you for that, because the issue is a concern. It's not having the resources to have the staff, it's having the staffing for what we were approved is my problem. With reviews like these, that could be interdisciplinary reviews by telemedicine or by video conferencing is appropriate, as long as a clinician has their impact and has the understanding of the history and can follow up medical or mental health on the individual so we can have an appropriate outcome.
So you believe you can put that program together effectively to accomplish the goals of this legislation?
Yes, I do.
Thank you for being here, and thank you for your service.
All right, any other questions about the bill for the director, the sponsor? All right, thank you again so much for being here. We do appreciate it. And I think that will allow us to accept an a motion to amend and do pass. All right, I'll take the motion from Vice Chair Harris and the second from Senator Krasner. And is there any discussion on the motion? All right, not hearing any. All those in favor say aye. Aye. Any opposed, nay. It is a unanimous vote to amend and do pass SB 307, and I will assign the floor statement to Senator Spearman.
All right, moving on, we're now at Senate Bill 322. This is a bill that relates to reckless driving. It was sponsored by Senator Stone and others. We just heard it here a couple days ago. Senate Bill 322 increases the penalty for reckless driving causing substantial bodily harm or death to a person, to a prison term of 1 to 10 years if the vehicle was not traveling 50 miles an hour or more over the speed limit. If the vehicle was traveling 50 miles per hour or more over the speed limit, the prison term is increased to 8 to 20 years. A court may not grant probation or suspend a sentence imposed for such a violation. If the violation occurs in a pedestrian safety zone or temporary traffic control zone, an additional 1 to 5 year term is added. In determining a sentence, the court is to take certain factors into consideration, such as the offender's criminal history, impacts to victims, and mitigating factors. There is an amendment that Senator Stone offered at the hearing on the bill, and it's attached on the following page. The amendment strikes sections 1 and 2 from the bill, retains the current 1 to 6 year penalty for reckless driving cases except those involving a speed of 50 or more miles an hour over the speed limit or that occur in a school zone or a pedestrian safety zone. And the amendment also allows judicial discretion regarding parole eligibility. I would note also, although it's not listed in the work session document, Chair, that Senator Stone has requested that the bill be referred to as Rex's Law, and I have been told by our legal counsel that that will happen as warranted going forward, and I'm happy to refer to the Senate Bill 322 as Rex's Law from here on out, and that's all I have.
All right, any questions about the bill or the amendments? Oh, Senator Stone.
Thank you, Madam Chair. On behalf of the Padgett family and myself, I'd like to thank the chair for hearing this bill. I want to thank the committee for the consideration of this bill, and I want to thank the Padgett family for flying up here to give tremendous value to their son's life, to ensure that no other family has to endure the crisis and the horrible issue of losing a child to a heinous crime like this. I also want to let the committee know that today would have been Rex Padgett's 15th birthday. So I don't know if this is by coincidence or if it's by divine intervention. I'd like to think it was the latter. And I appreciate your consideration today. I know the Padgett family is watching. Thank you.
Thank you for that, Senator. Are there any other questions or remarks before I accept a motion to amend and do pass? All right, I would now accept a motion.
So moved.
All right, we have a motion from Senator Orenshaw. I'll accept the second from Senator Krasner. All in favor, aye. Aye. Oh, I'm sorry. Discussion on the motion. Senator Harris.
Thank you, Chair Scheibel. The amendment has brought the bill a long way and allayed quite a few of my concerns. I'll support it out of committee today, but would like to reserve my right. Thanks.
Understood. Any other discussion? All right. All those in favor, aye. Aye. Any opposed, nay. All right. Then the motion passes to amend and do pass SB 322, and I will, of course, assign the floor statement to Senator Stone. And that brings us to SB 359.
Thanks, Chair. We're at, as you said, Senate Bill 359. This is a bill sponsored by Senator Orenshaw. We heard it here on the 28th of March. It relates to juvenile justice. SB 359 authorizes a court to order attendance or participation in counseling services in addition to community service for children who have committed various acts for which they have either been adjudicated delinquent or in need of supervision. The bill expands the definition of community service to include work or activity required by the juvenile court, including without limitation participation in tutoring or extracurricular activities, and adds attending or participating in counseling or psychological treatment to a list of activities that are allowed under informal supervision, so long as the child's act did not involve violence or the threat of violence and the child has not previously come before the court. The bill also authorizes courts to order a child with a minor alcohol or marijuana violation to attend or participate in counseling or psychological treatment in addition to or in lieu of performing community service, and it revises provisions governing the number of hours a court may order a child to perform community service and provisions governing the suspension of a driver's license or delay in the ability to apply for a driver's license. There is an amendment that was discussed at the initial hearing. It's from the Clark County District Attorney's Office. It's a friendly amendment. It's attached for your review. It expands the definition of community service to conform with guidance from the Office of Juvenile Justice and Delinquency Prevention regarding providing meaningful community service while holding a child accountable. And it strikes from the bill the reductions in community service hours. It adds job skills and employability components to community service, and it removes the fine for a first offense of truancy. That's all, Chair.
All right. Thank you. Any questions on the bill? Okay. We have a question on the bill or the amendment. Senator Don Darrow Loop.
Thank you very much, Madam Chair. Would it be permissible to have the district attorney come up and just not verify, but clarify their amendment? And
that is fine with me if a representative is willing
very
to
much
take the hot seat.
I think I missed an appointment yesterday, so it would be lovely to hear this. Thank you.
Thank you, Chair Scheibel. Bridget Duffy for the record, BRIGID, DUFFY. I had to pull up the amendment to answer Senator Dondero Loop's question. So, yes, the Nevada District Attorneys Association did submit an amendment after our last hearing to address some continued concerns. That amendment would have put the initial firearms charge up to 200 hours. It would also have verified that we have schools could be used for community service, and then, so activities within a school. And we remove the portion that would require the court, or that the court could require a child to talk about what they did in community service and how that connects to the goals of the community service. We remove that portion.
Okay, thank you very, very much for that clarification. I appreciate that.
Senator Orenshaw.
Oh, thank you, Chair. Just want to thank Ms. Duffy and all the folks at the District Attorney Association for working with me on this amendment. There was a lot of back and forth. I think that this will open up a lot of opportunities for kids who are on probation, who have been having a lot of difficulty in trying to complete community service when it's ordered by the court. So I do appreciate this. I think that the version, at least that I have in my work session document, may not be the latest version, because under the end of Section 4, I still see the language about the court may require the child to inform the juvenile court which of the goals in Section 1, subsection 1, the participation in the community service has assisted in helping the child achieve. I believe that language we'd agreed to delete. So I think that this may not be the latest version of the amendment that is in the work session document, but that language was agreed to be deleted.
Sorry. See how fast I was trying to run. Bridget Duffy for the record. Yes, Senator Orenshaw, I did send that additional amendment, so just for the record, it would strike that specific subsection out I sent that out last night at like 6, so I'm sorry it didn't
Oh,
make it
thank you.
through.
Thank you, Chair. I appreciate all the work with me on the amendment, and I think that was the only substantive change, I think, between this amendment and the last final version.
That is correct.
Thank you. Thank you, Ms. Duffy. Thank you, Chair.
Hold on. Senator Nguyen wants a, oh, okay.
I was gonna make a motion to amend and amend. And
Okay. Never mind. Okay. I will accept Senator Nguyen's motion to amend utilizing the amendment contained in the work session document plus a conceptual amendment to strike language in Section 4, subsection 2, indicating that the child can be required to come back to the court and talk about the goals achieved or that they made progress towards. So with that motion to amend and do pass, do I have a second? Second from Senator Stone. Discussion on the motion.
Thanks, Madam Chair. That is a friendly amendment. Is that my understanding that? Is you're okay with that? Okay.
Yes, that's a friendly amendment. Thank you
Very
to Ms.
good.
Duffy, and appreciate her working with me on that amendment.
Any other discussion on the motion? All right, seeing none, all in favor, aye. Aye. Any opposed, nay. All right, we have a vote to move SB 359 to the floor, and I will assign the statement to Senator Orenshaw.
Okay. Last bill on the work session today is Senate Bill 418, which revises provisions relating to candidates for the office of district judge. This is a committee bill. We heard it here on March 30th. The bill requires a candidate for district judge to submit with his or her declaration of candidacy the same application that is required by the Commission on Judicial Selection from a person who applies to fill a district court vacancy. It also requires the relevant filing officer to publish the application on the filing officer's internet website. There is an amendment provided that Senator Scheibel has offered in consultation with the courts. It's here for the committee's review. It strikes the original content of the bill and replaces it with the following, and I'll just read it into the record if you like, Chair. First, in addition to a declaration of candidacy required by NRS 293.177, a candidate for judicial office must file with the filing officer a questionnaire prescribed by the Supreme Court. The questionnaire shall include information on, but is not limited to, the candidate's education and qualifications for the judicial office for which she or he is filing a declaration of candidacy. Upon receipt of the completed questionnaire as provided in subsection 1, the filing officer shall post the completed questionnaire on the internet website of the officer, and as used in this section, declaration of candidacy has the meaning ascribed to it in NRS 2.30455, and filing officer has the meaning ascribed to it in NRS 293.057. That's it.
All right. Just to clarify, I did work with the Supreme Court and the court administrators on this amendment. What it essentially does is require a questionnaire to be filled out like we discussed in the hearing. Instead of utilizing the one that's already utilized for appointment candidates, it sounds like the Judiciary or the Supreme Court may actually be interested in developing a separate questionnaire. So they can either utilize the existing one or develop a new one, as long as there's something for judicial candidates to fill out that the elections official will then post on the website for interested voters. And with that, are there any questions on the bill or the amendment? Not seeing any, I would expect a motion to amend and do pass. All right, we have a motion from Senator Krasner, a second from Senator Orenshaw. All in favor, aye. Aye. Any opposed, nay. All right, that motion carries unanimously to amend and do pass, and I'll assign myself the floor statement for SB 418. And I believe that brings us to the conclusion of our work session. So it's time to go back to bill hearings. In the interest of time, I'm just going to ask, I'm sorry, is there anybody in the audience who is presenting a bill today that needs to get going and wants their bill called next? If not, we will go in numerical order, starting with SB 389. Okay, scratch that. We're not going to have the hearing on SB 389 right now. We will instead open the hearing on SB 408.
Good afternoon again, Chair Scheibel, members of the Senate Judiciary Committee. I am still James Orenshaw, and I'm still very lucky to represent State Senate District 21 down in Southern Nevada. Thank you for hearing Senate Bill 408. I want to direct all the members to Nellis or else to the hard copy amendment. I'd ask members to look at the amendment to Senate Bill 408 rather than the original bill. Senate Bill 408 is a bill that arises out of my experience in my practice as a deputy public defender in juvenile court, working with children who've found themselves cited or arrested and in delinquency proceedings and potentially in proceedings that can sometimes lead to them going to adult criminal court. Senate Bill 408 looks at changing the laws here in certain different ways. And with the amendment, I want to direct everyone there because this bill revises the age and conditions under which a juvenile may be certified to be tried as an adult and also revises provisions concerning certain sex offender registration for a person who committed a sexual offense as a child and who has now reached the age of 21. What the amendment does in Section 1 is it would create a uniform age of 14 for potential certification to adult criminal court. Currently under Nevada law, 14 is that age. However, there is the exception for murder and attempted murder, which goes down to 13, which is certainly an extremely rare case. But the premise behind deleting that and raising that to 14 is that I do believe that there are services that can be provided. If, heaven forbid, anything like that ever happened, and certainly we see that things like that do happen around the country, that the juvenile court would have jurisdiction over that rather than the potential of it being transferred to adult court and be able to provide those services. Additionally, Section 2 of the bill provides that a court is to relieve a child who turns 21 from sex offender registration community notification requirements unless the prosecution, the state, proves by clear and convincing evidence that that child continues to pose a threat. And certainly, I think you'll hear from some of the other co-presenters that children who are on what's called the JSO calendar, juvenile sex offender calendar, they're very, very low recidivism rates. Children who get the treatment that's ordered by the court in those juvenile sex offender cases have very, very low recidivism rates. So with your indulgence, Chair Scheibel, I believe I've got Jennifer Frazier from the Clark County Public Defender's Office in Southern Nevada on Zoom, and I think Christina Wildeveld, who's a private attorney who also represents children in juvenile court. I think she's also logged in on Zoom, although I don't see her. But if I could turn it over to them, and then I'm happy to answer any questions about the bill and the proposed amendment.
Thank you, Senator Orenshaw, and thank you, committee, for your time. My name is Jennifer Fraser, Jennifer. FRA, S as in Sam, ER. I'd like to thank the committee for taking the time to hear this bill. Just to echo Senator Orenshaw's explanation, really effectively the amendment for Section 1 simply increases the threshold from 13 to 14 for that one offense of the murder offenses. So this is a very small portion of the delinquency cases that we see. So this wouldn't have a significant impact, but incredibly important for those cases, those rare cases that do come up with the recognition that a 13-year-old, no matter how serious the offense he or she commits, is not appropriate to be transferred to the adult system. This committee will hear later today another bill regarding probation time limits, but again, that would be carved out, murder and attempt murder offenses. So for a 13-year-old would still have 8 years of jurisdiction in the juvenile system. And I think that would be an appropriate time to be able to get rehabilitation and services. And again, this is a very rare rare instance, but still important for us to keep as many kids out of the adult system. Section 2 is also a very important piece of what we do in the juvenile system. I want to point out that this doesn't change the presence of juvenile registration. And it would be amending 62F 340, which allows the court to hold a hearing for a child, well, they're not a child, on or about their 21st birthday. So if they have certain statutory sexual offenses, the court has to have a hearing to determine if they should register as an adult sex offender based on an offense that was committed when they were 14 or older. This amendment, this bill, simply would shift the burden from the juvenile to the state. It's our position that the state should have the burden to show to the court that that child, or now an adult, is no longer a safety risk. I think this is important because of the negative consequences surrounding registration. We know how it affects a child and an adult's mental health, harassment, unfair treatment, problems at school, increases suicide risk. And I think shifting that burden from the juvenile to show that he's rehabilitated versus putting that burden on the state, because it is such a significant ask, is excuse me, is important and would get rid of any erroneous findings of putting too many people on the registry, which in fact reduces community safety. And for that, I'd ask the committee to pass the amendment to this proposed bill. Thank you.
Thank you. And Chair Scheibel, James Orenshaw, State Senate District 21. I reached out to Ms. Wildeveld, but somehow she's having a little trouble with the Zoom link. I know she did want to help co-present this bill, but it seems like she's having a little bit of difficulty logging in. With that, I just want to let the committee know that the amendment I'm presenting takes into account some concerns that stakeholders had, and I'm still trying to work with those stakeholders, trying to see if there are any other concerns that I can address. But so it's bill's still a work in progress, but yeah, I believe in the policy, and I'm happy to answer any questions about it.
All right, thank you. Questions for our presenters about the bill? I don't see any questions. All right then, we will go to testimony in support of SB 408. Anybody wishing to give in-person testimony is invited to the front of the room in Las Vegas or Carson City. We'll start in Carson City. Go ahead when you're ready.
Thank you, Chair. John Puro from the Clark County Public Defender's Office. We'd like to thank the Senator for bringing this bill forward, and Ms. Frazier from my office for helping present. We think this is a good first step and a good measure when looking out for children that have been involved in this, and that we think that it also actually puts the burden where it should be when it comes to whether or not we keep a kid on the registry. Thank you.
Good afternoon, Chair, members of the committee. Erica Roth on behalf of the Washoe County Public Defender's Office. I echo the sentiments of my colleague, Mr. Puro. I do want to thank the bill sponsor for bringing this forward and note that it is a good first step, especially in regards to shifting the burden that is in line with case law and when we're looking at the rest of our statutes. So we believe that's appropriate. Thank you.
Thank you. I don't see anybody else coming to the table in Carson City, so we'll go to Las Vegas. Go ahead.
Good afternoon, Chair and members of the committee. For the record, my name is David Beltran Barajas. I'm the immigrant rights organizer and mass incarceration organizer over here at the Progressive Leadership Alliance of Nevada, here in support of Senate Bill 408 to increase the age of certifying a juvenile into adult court from 14 to 16. The practice of certification in direct file disproportionately affects and impacts youths of color. From 2012 to 2017, 140 of 147 youths directly filed into adult court in Clark County were youths of color. Of the 147 youth directly filed into adult court, 69% were black youths, which hovered around 10% of the Clark County youth population during the period. As a brown male, one of my parents' worries while raising me was to ensure that I never had any contact with the criminal justice system, mainly because of my undocumented status growing up, but also because they recognize that entanglements with the law for young brown boys often means getting sucked into the prison pipeline. My own mother grew up without a dad. Carmelo was his name. He was in and out of the prison system from a very young age, and would go on to miss my mother's entire life. In refraining from certifying youths as adults until 16, we create one more backstop in keeping our youths of color out of the prison pipeline. This provides our communities with the ability to take a restorative approach to how we deal with crime and forgiveness. If we show our youths that there is no room for forgiveness, what hope do they have for rehabilitating? I urge you consider the damage these policies have created in our past and ask you support the changes outlined in Senate Bill 408. Thank you for your time and consideration.
Thank you so much. I don't see anybody else in Las Vegas wishing to give testimony. I understand that Ms. Wildeveld may have joined us by Zoom. That's my invitation to her to present. But if my intel is wrong, then we will go to the phones for testimony in support of SB 408.
SB 408. If you would like to testify in support of SB 408, please press star 9 to take your place in the queue. We have no callers to testify in support.
All right, we will move to testimony in opposition to SB 408. That is the bill hearing we're in the middle of. And I'll invite anybody wishing to testify in opposition to come to the tables in Carson City or Las Vegas. We'll start with those folks here in Carson City. Please go ahead whenever you're ready.
Good afternoon again, Chair Scheibel and members of the committee. This is where Senator Orenshaw and I have not come to an agreement yet, but I do appreciate it. It's kind of weird. We've had such good communication about these juvenile justice bills, and we have been working through this one, but we have not come to an agreement. And on behalf of the Nevada District Attorneys Association, I am going to put our opposition on the record. And I want to take my brief moment to just make sure this committee understands what a certification is. So a certification isn't an automatic, you bypass juvenile justice and you go to the adult system. It's a process before a juvenile judge. And over the course of several legislative sessions going back to 2013 when we put the age of 13 in the statute for murder and attempt murder, we have been moving away from certain things. One of them is presumptive certifications. No longer do we presume in certain occasions that a certification should occur. Everything is discretionary on the part of the court. So in that process, my office or the state or any office of the prosecutor would file a motion, and the attorney for the juvenile would file an opposition, and then there are evaluations of the juvenile. And then a judge in his or her discretion would weigh factors to decide if the case warrants transfer to the adult system upon the serious nature of the offense and past adjudication. So if the child has been through the system and has received services before, or if the court believes that the juvenile can be rehabilitated in the juvenile system. So there are protections in place. And in Clark County, I have not had a 13-year-old yet. I have had 14-year-olds. I have Washoe County with me. They can discuss their history. But if I'm not sure I'm there for 13-year-olds, because when we look at the world we're living in today, I can't imagine now, sadly, a world where a 13-year-old takes a firearm to a mall and kills other children. And I'm not saying that 13-year-old would be necessarily appropriate for the adult system, but that's the court's discretion to make that call. And with those protections in place, I do not believe we need to change any more of what we have for certifications. As to Section 2, the District Attorneys Association is opposed to that burden shifting to the state to prove that they are likely to pose a threat, and that currently that having that child, because you have to understand, sometimes we don't see these children for years after they leave, and they have to come back at 21 to determine registration. So we'd have to have evaluations, we'd have to see what was going on for the last few years, and to have that individual just have to tell the court what's been going on, we felt is the better way to handle it, which is currently in statute. Thank you.
I'm going to ask you to remain in case there are any questions for you. All right, I don't see any. Thank you, Ms. Duffy. Oh, I'm sorry. Senator Harris.
Thank you, Madam Chair. Ms. Duffy, you mentioned, a 13-year-old maybe committing a heinous crime. Is it your opinion that that changes the fact that they're 13? I mean, are we supposed to, I guess, feel like because they did something horrible that they deserve to be treated as an adult as opposed to still being a 13-year-old?
Bridget Duffy for the record. I think that's a factor for consideration of the court when determining whether or not the crime was enough that they would have to be served in the adult system. In juvenile, I mean, we don't have anything. We have been asking for session after session to create programs that would help us to treat violent offenders in the juvenile system until they turn of age. But we don't have anything. Well, there's frankly nothing in the adult system. But that would be a court's decision. And I can't even tell you that I would even motion the court at that point because I don't know the facts of the case. But in today's world, I can imagine we'll get one, and I should be able to weigh it, and I should be able to take it to the court for their discretion to see if they can be treated with whatever we create. Hopefully we create something for these children in the juvenile system. But right now we have nothing. And residential treatment facilities will not take violent offenders to treat mental health.
Senator Wynn.
Sorry, I have a newly 13-year-old, and I guess piggybacking on that, I mean, what is it right now why is it right now that 13 is acceptable, I guess, to not look at, I mean, you're talking about the facts of the case and not the facts of like that child. When we talk about how brains haven't developed until like 13, not at 13, but at like 27. So what kind of factors do you think a court would take into consideration, or you would take into consideration in determining whether or not that is a low enough number?
We would take into consideration the heinous and egregious nature of the offense, the age, the maturity, whether or not the child's received treatment in the juvenile system in the past. So most likely would probably weigh in favor of not moving to certify that child because we don't often get 13-year-olds in the system. Now, we've had 14-year-olds that are just a month or two away from being 13 that have taken stolen vehicles and driven them through intersections at 100 and some miles an hour, killing a innocent person in their car on their way home from work. So, I mean, you keep talking, like, it's discretionary. It's not mandatory. And I have my Washoe County partner here because I asked her if she's had 13-year-olds, and she has, so perhaps she could fill in on what those facts and circumstances were. It hasn't been for maybe a decade, but there have been those circumstances. And again, the fact is we need to have, it's discretionary. It's not mandatory.
I'm just concerned that we're creeping down lower and lower, and we've seen states around the country where you have like an unfortunate situation where perhaps like someone had access to a firearm that was unsecured, and you have a 10-year-old that has killed like multiple kids. That child's still 10, and that is an egregious like act that occurred, but I just get concerned that we're creeping down further and further and not looking at the science and, of like brain development and emotional, emotional like maturity. I mean, you're talking about children that potentially haven't even, most of them haven't even gone through puberty. You could have a 13-year-old girl who hasn't even had her first menstrual cycle. So I just have concerns that we are talking about not even just children, we're talking about babies.
Bridget Duffy for the record. So just to respond, Senator Nguyen, we're not creeping down. 13 is the current age. So that's the current age. So I'm not asking for it to be lower. I'm asking for it to remain 13. We have, which eventually will be over on your side, conversations in the assembly side, constantly talking about a 6-year-old who brought a gun to school, right? And now they want to have all these children kicked out of school and into the streets because they're violent offenders. So everybody's okay with that. Just kick a kid out of school because they're 6. So we can't reconcile all of this, right? We can't. How do we reconcile schools aren't safe because a kid acts out at school, so let's put him into the street. And then they put him into the street with no education. I can guarantee you I know where they're going to go. So I hope that in consideration of all of these things that are coming for this body, you reconcile it. You reconcile it, because we can't. And so I just say, right now, we are working in a system where the court has discretion, and that is a good thing, because it's not fully in my hands, and it doesn't bypass us altogether. And we have people that consider things and make the best determination for both public safety and the interest of the child.
And thank you. And just to follow up, I'm not directing at this. I know that your interest and what you have strived your entire career is to protect children and make sure that they're in the best situation possible. I just get frustrated that when we have conversations about moving the age up, even minimally for our young people, 13, 14, that you're not even in high school at that point. You're in, a middle school situation. You gave an example about joyriding at 14. You can't even drive at that age. And so, I just have concerns about that. So thank you.
All right. I think we've covered it, and I think we're in the middle of opposition testimony to SB 408, and we'll go ahead and continue.
Good afternoon, Chair Scheibel and the Senate Committee on Judiciary. My name is Chris Reese, it's R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. I'll be brief, and I just want to echo Ms. Duffy and the Nevada District Attorneys Association, leaving the discretion up to the courts. Thank you.
Good afternoon, Chair Scheibel and members of the Senate Judiciary. My name is Elizabeth Flores, E-L-I-Z-A-B-E-T-H, Flores, F-L-O-R-E-Z, and I am the Director of the Washoe County Department of Juvenile Services. I echo the concerns expressed by Ms. Bridget Duffy. In 2021, SB 356 required a study be conducted on the housing of youthful offenders. This report is due to the legislative body before June 30th of this year, 2023. We support the belief that certified youthful offenders should be in a setting that provides for their unique needs based on their development. We also believe making changes to the certification laws prior to analysis of the SB 356 report is premature. For this reason, we are in opposition. I will add, in response to previous questions, in Washoe County, we have had 2 13-year-olds. It was about a decade plus ago that were charged with murder and certified. And that ends my testimony. Thank you.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Jeff Rogan. I represent Clark County, and I'm here today testifying on behalf of our Department of Juvenile Justice Services. The question was brought up a moment ago about raising the age for certification. And I want to draw to your attention that this bill, as drafted, would have placed significant burdens on our juvenile justice system because we simply don't don't have appropriate facilities for children who commit violent offenses who are 16 and under. We anticipate that we would need if this bill were to pass as drafted, we'd need 2 additional facilities to house those children, as well as approximately 26 new staff. So whenever we're talking about changing those age ranges, we have to talk about the facilities and personnel that would be needed in order to ensure that those children remain safe in those facilities. So I think some of this amendment will address those concerns that we originally had, since it does revert back to the age of 14. But I do want to make it clear that if you are considering changing those ages, there are repercussions on the local level. Thank you.
Good afternoon, Chair, members of the committee. Jason Walker, Washington County Sheriff's Office, testifying in opposition to Senate Bill 408.
All right. I don't see anybody else coming up to give opposition testimony in Las Vegas or Carson City, so we will go to the phones for testimony in opposition, please.
If you would like to testify in opposition of SB 408, please press star 9 to take your place in the queue.
Casey Rogers for the record. I'm just opposed to this bill, just letting it be known. I echo what everybody else has said prior. Thank you.
There are no further calls to testify in opposition.
All right, thank you. We will move to neutral testimony on SB 408. Anybody wishing to give neutral testimony is invited to the front. Not seeing anybody, we will go to the phones for neutral testimony on SB 408.
If you would like to testify in neutral for SB 408, please press star 9 to take your place in the queue.
Hello, my name is Yesenia Moya, Yesenia Moya. As a community educator, organizer that helps youth learn to advocate for themselves, I came here initially to support this bill as it was written. With this amendment, I know that it is still a good thing, and yet I am so concerned about what the opposition just said. I think our youth deserve multiple chances in various different ways. They deserve every single alternative and opportunity, because I've seen too many of my personal family members and friends end up in prison because they started out in juvie, period. And so it hurts my heart to hear people dehumanize 13-year-olds, to think that a child has the ability to be what the opposition has said, that I won't repeat. And our youth deserve better. So that's why I'm here testifying in neutral.
There are no further callers testifying in neutral.
All right, then that brings us to the conclusion of testimony. If the sponsors would like to come up and make any closing remarks.
Chair Scheibel, members of the committee, James Orenshall, Senate 21. Appreciate your indulgence on this bill. Certainly this is a difficult issue. One of the best things I heard today was the testimony from the prosecutors as to how extremely rare it is to see a 13-year-old charged with murder or attempted murder. Certainly, working in delinquency courts, the judges, the DAs, the public defenders, the probation officers, we see tragedy every day, human tragedy that affects children, affects families. And if we get to the point where we have a 13-year-old who's charged with murder, attempted murder, it's a tragedy for the child, for the victim, for society, and it's really the result of a lot of successive failures. Of so many things have failed that child that they got to that point that they're being charged. I believe that leaving it open for a 13-year-old to be prosecuted as an adult, potentially sent to Nevada Department of Corrections, would be another failure. And I think that that's a change that really we should make in the law. In terms of the children who had juvenile sex offenses and are now 21 and are seeking to not be subject to community notification registration, as I said, the statistics as to recidivism for those children who are charged with the JSO offenses, the juvenile sex offenses, extremely low recidivism rates. They usually do very, very well, and very often never see them again. So I think that it would certainly be fair for the burden to be on the state to prove that they need to be on subject to registration community notification if they've gotten into other trouble that somehow the court's not aware of when they turn 21. And Chair Scheibel, with your indulgence, if I could turn it over to Ms. Fraser, I think there's a couple of closing comments she'd make, and I appreciate your time.
Thank you, Senator Orenshaw, and thank you, Chair Scheibel. Just a couple of comments to close this out. I appreciate the questioning that we just heard, and I think everyone understands the brain science and adolescent brain development science, especially when we're talking about a 13-year-old, no matter how serious the offense is. There was some testimony regarding a bill studying the youthful offender housing within our state, with the recognition that there's room for improvement there. So I think we're moving 13-year-olds from getting escalated into the adult system is the right solution here. As far as Section 2, this isn't taking any discretion away from the court and being able to order registration. If it's warranted, this is simply shifting the burden to the state. I think the state is aptly prepared and has the tools to argue in instances where they believe there is a continued risk to the safety based on a subsequent criminal offenses, subsequent sex offenses. The state is certainly in a position to be able to make those arguments, and it's more in line with constitutional due process to have the state have that burden when asking for such a serious and significant collateral consequence for our children. And with that, I appreciate the committee hearing my testimony and considering this bill. Thank you.
Thank you so much for your presentation. That will close the hearing on SB 408. I'm going to do something a little unconventional, if you don't mind. We're about to lose our feed to Grant Sawyer in Las Vegas. I see that we have one person here in Las Vegas. If you don't mind coming to the mic and letting us know if there's a particular bill that you're here for, that way I can accommodate.
Luke Dumoran, and I'm here for AB 411.
Oh, we already heard SB 411.
I understand. I knew Judge Bailey went first because of her schedule, but I thought we might come back to it for some other topics. But if we're done, then I'm done here today too. Thank you.
Okay, if you want to put your name on the record and whether you're in support or opposition, we'd be happy to record it for you. Well, if you want to give us your name and whether you're in support.
My name is Dumoran, D-U-M. Sorry, I'm nervous. D-U-M-A-R-A-N, and I have to be neutral in testimony. I'm a state employee.
Got it. All right. Well, we certainly appreciate you being here and appreciate your participation. We have closed the hearing on 411. I've now closed the hearing on SB 408. And if there is anybody else who I can't see in Las Vegas who still wants to participate, the phone number to call in to give testimony is located at the bottom of the agenda, which should be there in the hearing room. So you can call in to give testimony in any position on any of the 3 remaining bills we have to hear, which includes SB 410. And we will do SB 410 next. I'll now open up the hearing.
Good afternoon, Chair Scheibel, members of the committee. Thank you very much for hearing Senate Bill 410. I thank you for your indulgence in hearing so many of my bills related to juvenile justice today. Still, James Orenshaw representing Senate 21. I'm very lucky to have Rick McCann here with me to help us with some questions and presentation on Senate Bill 410. I would like to briefly summarize the bill and then open it up for questions, Chair, after Mr. McCann speaks. Currently, Nevada law allows an applicant or an employee of a juvenile justice service entity who has been charged with one or more of a list of serious crimes 180 calendar days after arrest to resolve pending charges before the entity is to deny the application or terminate the employee. Senate Bill 410 changes that window to 270 calendar days after arraignment to provide that employee or applicant adequate time to potentially clear their record. Additionally, the bill defines a substantiated report of child abuse or neglect as one that has been assigned a disposition of substantiation by a child welfare agency and that is not the subject of an administrative appeal. For the purposes of this bill, such a claim is one of the factors for which an employee or applicant can have their application denied or their employment terminated. And Chair Scheibel, with your indulgence, working in the juvenile courts, I've had the opportunity to work with so many juvenile probation officers, staff, detention staff. They're in the holding cells prior to court hearings. And I've been so impressed at how much the detention staff, the probation officers, care about the children. I think they try to fulfill the role of social worker, mentor, being like an extra parent, big brother, big sister to so many of the children that they supervise and try to help. This bill really tries to aim at a little more fairness in terms of some of the conditions of employment for those people. We're working towards an amendment. I know Mr. McCann's been working with Clark County on an amendment to this bill, and it's not complete yet, but I believe that we're getting close. And with that, Chair Scheibel, I'd like to turn it over to Mr. McCann.
Good afternoon, Madam Chair, members of the committee and staff. Rick McCann, Nevada Association of Public Safety Officers and a member of the Nevada Law Enforcement Coalition. First, I wish to thank Senator Orenshaw for sponsoring this bill. I think most of us know that Senator Orenshaw has always been a champion for juvenile justice. I think if we didn't know it before then, we saw it today regarding issues and the hardworking men and women who work in that environment. He just stole all my thunder, so I'm just going to have to go through my notes real quickly and cross out some of this crap. Bottom line is the problem we have with this thing is that this bill seeks to remedy a particular problem we're having with timing. It takes a while to get an arraignment in misdemeanor cases. Much more time often than they have in the 180 days. Bless you. It can be more than 180 calendar days to get from the time of arrest to get yourself to a position where the criminal justice system is starting to work, and therefore you can start to remedy the situation by getting your case resolved in some fashion and avoid, of course, being terminated at your job. Things just don't start working until you get an arraignment or some form of a criminal charge that is officially filed. Law enforcement will tell you all the time, especially on misdemeanors, it can take a lot longer than what we would expect in a felony matter, for example. In all fairness, there is a discretionary portion of this bill that gives the discretion to the director to be able to extend that time, and in fairness, they have done so. I would be remiss if I didn't give them credit for doing that. But they don't have to, and oftentimes they do not, and people are sitting around going, well, I can't really do anything with my case because it's not in the system where I can. Meanwhile, time is running and they're going to be terminated. Simply put, things in the criminal justice system don't work, at least start, until after the arraignment or the initial appearance. So that's the time when the employee can really act to clear their records. Long story short, if we're going to give an employee, per statute, as we already do, time to correct their record before suffering termination, we darn well need to give them enough time. For those reasons, we ask that you support SB 410. As I said, I made my comments brief because Senator Orenshaw gave a good presentation of his own. But one other thing, we are working with the county, who will come up here, Mr. Rogan will come up here shortly and tell you that, to try to work out a couple of amendments if we can. So this matter, we would hope would pass through the process now, but there may be a couple of small amendments we would like to offer at some point. Thank you.
All right, questions from members of the committee. Senator Wynn.
Can I find out what the origin of this bill was? Were there so many, I guess, people being accused of child abuse and neglect that we're officers.
James Ornshaw, State Senate District 21, to you and through you, Chair, to Senator Nguyen. I don't believe that there were so many, and I don't have the numbers. I think maybe Mr. McCann might have that. I think that there were concerns that, Mr. McCann reached out to me and sought this change for more fairness for the employees who work there. So, Mr. McCann.
Rick McCann for the record, through the chair. Senator, now you're going to get into my notes. Thank you. Okay. Current law, which is NRS 62G.223, states that the Department of Juvenile Justice Services can secure from appropriate law enforcement agencies information on the background and personal history of every applicant for employment with a department and each current employee of the department to determine whether the applicant or the employee has been convicted of a list of about 14 categories of crimes. That's all set forth in 62G.223. And this investigation is supposed to be performed about every 5 years. Current law indicates, the same statute, 225, the portion of 225, 62G.225, states that if an applicant or an employee has charges pending against them for one of those listed crimes, the Department of Juvenile Justice may, the word may, deny employment to the applicant or may terminate the employment after allowing that person time to correct the information to resolve the charges. And as Senator Orenshaw referenced, a 180-day time frame, that comes under NRS 62G.225, which states that an employee, if they have pending charges against them for one of those listed crimes, the Department of Juvenile Justice shall allow the employee a reasonable time of not more than 180 calendar days after arrest to resolve the pending charges. And the Department of Juvenile Justice may allow the employee additional time to resolve the pending charges. As I indicated parenthetically before, the department has, in fact, exercises discretion to extend it, but not always. What we're trying to do is say 180 days from arrest, you may not even have an arraignment within that period of time. So let's make it 270 days, which is what the bill is in front of you, from the time of arraignment. At least put them into the game when they can play. They can't play the game and get this matter resolved until there has been an arraignment and formal charges. We're asking for that additional time to start from arraignment, not from arrest. And again, to answer your question, Senator, we go back to 62G.223 for that list, enumerated list of violations. Many felonies, a couple of misdemeanors in there. Not all just dealing with child abuse. There's a variety of things in there, from DUIs and things of that nature. If that answers your question.
It does answer part of it, and that kind of brings me to another question. Obviously, we have this section in 62G.225, subsection 2, subsection, section 1, subsection B. Right at the bottom of the second page, where you've deleted the has had a substantial report of child abuse or neglect made against him or her, but has not been satisfactory that cleared. Can you kind of describe why that section, that deletion is needed and that new subsection C is needed?
James Orenshaw, State Senate District 21, through you, Chair, to Senator Nguyen. I believe, and if I'm wrong, then I might need a lifeline, but I believe that's because of our recent changes to statute regarding whether, I think in the past, if there was an allegation of abuse or neglect of a child, there was either substantiated or unsubstantiated, and I know that recently there was a change to 432B point, Chair's indulgence, I believe it's 432B.305, that also gives some other options. I believe that's why the language reappears there with the change, but if I'm incorrect.
And I don't know if legal might be able to answer whether or not that is a conforming change because of other section changes, or if that is like a substantive part of this bill.
Carly O'Krent for the record. Senator Nguyen, I heard you refer to a paragraph C, and I'm just not seeing a paragraph C. If you could refer me to the section that you're talking about, I might have misheard you, but.
Sorry, section 1, subsection C. Top of page, that's it, top of page 3. Sorry, I have my black and white copy here in front of me.
Carly O'Krent for the record. I'm sorry, I just need to grab the right bill. That might be helpful.
And if James Orenshaw, State Senate District 21, certainly I think the deleted language does not include the granting of the employee the time to correct the information as required. Because I think the new language there at the top of page 3 also takes into account that if the employee believes there might be an error in that central registry, this would give them the time to make sure that that is potentially corrected and potentially their career in juvenile probation or juvenile detention would not be over if there is an error, which I don't believe that the original language of the statute had that.
Senator, I'm happy to provide any additional information that you like. My general understanding of the need for paragraph C is simply that, the senator's explanation regarding the recent change in requiring the assignment of a disposition to these reports of abuse or neglect is correct. And the language regarding the assignment of that disposition allows a report to be assigned a disposition of substantiated but still be under the appeal process. And so while an appeal is pending, what they're trying to do is build in a time frame that would allow someone to not be, fired during that time period. And so hopefully that gets at your question. If not, I'm happy to follow up.
No, that does. And I guess my follow-up to that also, and maybe it is also like related to that too, is on the very last page, on page 4, there is a new definition for substantiated report of child abuse and neglect. That appears to be new. Is that conforming language or is that new?
James Orenshaw, State Senate District 21, through you, Chair, to Senator Nguyen. That new language at page 4 references us to chapter 432B.305, and in 432B.305, the definition of substantiation is still, it's already in statute at 432B.305 sub 3B. Substantiated means that the agency which provides child welfare services has determined by a preponderance of the evidence that the alleged abuse or neglect occurred and was committed by the person named in the report as allegedly causing the abuse or neglect. So it refers us to the existing statute. I know that, I believe it was last session that we made some changes to that statute, because before there was only the option of substantiated, unsubstantiated. We did add unable to locate or contact the person against whom there's the claim, or administrative closure against the person there's a claim of abuse or neglect. So this gives more specificity and does refer us to existing statute and
Thank you.
Madam Chair, I'm sorry.
Oh, please go ahead.
May I offer one other thing for the Senator's consideration? We're talking a little bit about two different things too, because there is that list of criminal violations in 223. We're also talking about administrative proceedings that can be taken that will result in a substantiated report of child abuse. Those administrative things are not necessarily yet criminal charges. We wanted to make sure those are included in the time frames we're talking about as well, if that makes sense.
All right. Any other questions from the committee? I don't see any, so thank you for your presentation and for answering our questions. We will move to testimony in support of SB 410. Anybody wishing to give testimony in support is invited up to the tables in the front of the room. Looks like we still have Las Vegas somehow, but we'll start here in Carson City.
Afternoon, Chair Scheibel, members of the committee. I'm John Abel, Director of Government Affairs for the LVPPA, and we support the bill. I can just tell you what Metro does with people that are accused of crimes, whether they're felony or misdemeanor. If you're accused and you're of a felony crime, Metro puts you on unpaid admin leave. They don't terminate your employment, but you're not in a paid status. So if you can prove yourself to be innocent, then or charges are amended or dropped, you can come back to your job. And if you're accused of a misdemeanor, then you are sometimes placed on admin leave with pay, or they modify your duty. So I don't know if that's an easier way to handle it, but that's how we handle it. But we support the bill. Thank you.
I think Senator Hansen has a question. Go ahead.
Thanks, Madam Chair. When they if they've been accused of a felony and they get exonerated, do they get their back pay?
It depends. If they are exonerated, so I've been through that, not me personally, but I've had officers that have been through this. If the charges are dropped or they are acquitted, yes, they will get back pay.
Okay.
But if they take any kind of deal, they don't get back pay.
Thank you.
Oh, John Abel for the record. Thank you.
All right, thank you. I don't see anybody else coming up to the table in Las Vegas or Carson City, so we will go to the phones for testimony in support of SB 410.
Thank you, Chair. If you would like to testify in support of SB 410, please press *9 to take your place in the queue.
Tanya Brown, TONJABROWN. We are in support of this bill. We have come across in the past where allegations of child abuse, sexual child abuse, has come up, and it's primarily in divorce proceedings, where one spouse will allege the other spouse alleging child abuse. And then later on, it turns out that it was not true, but in the process, it has destroyed the other person's life, their jobs, and really caused problems between the children and the parents. But yes, we do support this bill. Thank you.
This is Matthew Richardson, MATTHEWRICHARDSON. Thank you, Senator Orenshaw, for bringing this forward. Thank you to the chair and the committee for hearing it. What this bill does for us is it allows time for due process to take its course before penalties are levied, and just gives us a fair shot at clearing ourselves before we're terminated or pushed out of our career. There was a senator that asked a question about, how often this happens, or what's the frequency of a supervisor or officer being accused of child abuse. In the last 3 years, there were 3 supervisors that were charged for child abuse, and they were all exonerated from any wrongdoing. And what the problem is just the time to get that fair hearing. And that fair hearing takes about 5 months or longer to get. There's that administrative process through Child Protective Services, and then there's the additional time to actually get or receive a findings. And so, the timelines are very skinny, and so we're just really asking to widen them just so people can get that due process and have a fair chance. Thank you very much.
There are no remaining callers testifying in support.
All right, then we'll move to testimony in opposition on SB 410. Anybody wishing to give in-person testimony is invited to the front now. We'll start here in Carson City whenever you're ready.
Good afternoon, Chair Scheibel and members of the Senate Judiciary Committee. My name is Jeff Rogan, representing Clark County, and here again on behalf of our Department of Juvenile Justice Services. I'll also be brief, as Mr. McCann was brief. What we're really talking about here amongst those enumerated crimes is DUI. When a person is arrested for DUI, they can either take a breath test or a blood test. And if you take a blood test, it takes time for that blood to be analyzed to determine what the blood alcohol content is. So that delays an arraignment, perhaps by 3 to 4 months. And we recognize that, and Mr. McCann and I are working on an amendment to address kind of that specific issue. The remaining types of crimes, usually when the arrest is made, the arraignment is happening very quickly thereafter. And so in those other crimes, it's not really an issue that an arraignment is delayed substantially. The other concern that we have is with the definition that was brought up, the change in definition of a substantiated child abuse or neglect. The way that it reads right now is, in this bill, is if a person has not obtained their fair hearing, they are not considered to have a substantiated child abuse, which means that we cannot prohibit them from interacting with the children that they supervise. So that's the second area that we're concerned with, that we're working with Mr. McCann to address, and I would say he's been very great to work with, and I think that we'll have something resolved by this afternoon. So thank you very much.
All right, thank you. I don't see anybody else here to give opposition testimony. So we will go to the phones for opposition testimony on SB 410.
If you would like to testify in opposition for SB 410, please press *9 to take your place in the queue. We have no callers testifying in opposition at this time.
All right, then we will move to testimony in neutral. Anybody wishing to give neutral testimony in person is invited to the tables in Carson City or Las Vegas. But I don't see anybody coming up to give neutral testimony. So we'll go to the phones for neutral testimony on SB 410.
If you would like to testify in neutral for SB 410, please press *9 to take your place in the queue. We have no callers testifying in neutral.
All right, then. That brings us to the conclusion of testimony. If the presenters would like to make any closing remarks.
Chair Scheibel, members of the committee, James Orange, Senate 21. I want to thank Mr. McCann, Mr. Rogan, Clark County, trying to work on an amendment, trying to reach compromise. Again, I believe the men and women who work with the children who find themselves in detention, on probation, are some of the most dedicated people I've ever met, and I just want our statutes to give them a fair chance to clear their names when there are accusations like this, so that their careers don't end when there's a chance that their name will be cleared and that these charges were not correct. So I thank you for the time. Thank you.
All right, thank you. This concludes the hearing. I will now close the hearing on SB 410 and turn the gavel over to our vice chair.
committee will stand in a brief recess at the call of the chair. Okay, we'll go ahead and call the committee back to order and resume the hearing on Senate Bill just kidding, Senate Bill 389. We know what we're doing, we promise.
Thank you, Vice Chair Harris. For the record, my name is Melanie Scheibel. I am State Senator for District 9, and I am delighted to be joined by my colleague, Senator Heidi Seavers-Gansert, to present to you SB 389. To understand kind of the purpose and the structure of SB 389, I'm going to give you a background on where this came from. Every year that I've been here, we've come to the legislature and worked tirelessly to try to prevent human trafficking. And we try to combat human trafficking in a myriad of ways through various provisions of services from the government, from nonprofit agencies. We try to work with law enforcement. Law enforcement has their own programs designed to address human trafficking, to prevent people from engaging in human trafficking, and to serve survivors of human trafficking. And yet we continue to come back to the legislature and harp on just how bad the problem of human trafficking is. And we do that because it's true, because human trafficking continues to persist in the world and in the state of Nevada. And so this year, I thought that, it certainly wasn't the time to give up on trying to prevent human trafficking in the state of Nevada, but it was time to take a step back and ask ourselves, what have we been doing, what has been working, and what hasn't? And so when I started to do that, I discovered no less than 7 governmental bodies that are explicitly and exclusively committed to combating human trafficking. And some of those bodies have come to speak to us in the judiciary or in the interim judiciary. Some of them have not. Some of them have functional websites that tell you exactly what their mission statement is and what they're here to do, and some of them do not. And this is not a way to complain about any of those agencies or suggest that they're not doing their jobs, but I don't think that they're coordinated. We tried last session to facilitate that coordination by developing a statewide human trafficking task force. All that did was create yet another body that was supposed to coordinate all of this. And it did meet. It met twice that I know of, and the minutes have not yet been updated. And it is staffed by the same groups that staff the Southern Nevada and Northern Nevada Human Trafficking Task Forces. So in other words, we have done an excellent job of creating committees and task forces, and we've not done an excellent job of coordinating those committees and task forces. So rather than create yet another one, what SB 389 does is a couple of different things. Number one, it takes one important piece of the puzzle that was missing for actual enforcement, which was to address which was to ensure that people who are trying to buy sex from a child online are punished the same whether they are actually interacting with a child, a member of law enforcement, or somebody working with law enforcement posing as a child. And that last little section was missing before. We hadn't really contemplated the idea that law enforcement agencies would partner with other people who were not law enforcement officers themselves, but posing as children. So that's one piece of the bill. The second piece of the bill gets to that disjunctive bureaucratic nightmare that we have created of multiple agencies and nonprofits and task force and committees that are supposed to be addressing human trafficking, and it directs them to issue one consolidated report to the interim Judiciary Committee next year. It doesn't specify who is in charge of the reporting. It doesn't put one person at the top of the food chain. It doesn't declare that we are going to appoint anybody new to work on this problem, because frankly, I think we do have the best and brightest working on human trafficking issues in the state of Nevada. I don't doubt that there are dozens, if not hundreds or thousands of people committed to preventing and fighting human trafficking in Nevada. And in the time that I've worked on this issue, I have met dozens of people who do great work in this area, but we're not leveraging the resources that already exist to make the Northern Nevada Human Trafficking Task Force, the Southern Nevada Human Trafficking Task Force, the State of Nevada Human Trafficking Task Force, and all of the other committees as effective as they can possibly be. So the purpose of requiring all of these agencies that are defined in Section 4 of the bill is to ensure that anybody who receives money from the state to do work combating human trafficking, or is part of a task force or committee that was established by statute to combat human trafficking, comes together to produce a report that details what they are doing and how they are involved in this process, to force them to the table together all at once and create a single document that will help the legislature. It's like an audit. It's like an audit for the legislature to understand what all of the bills that we have been passing over the last 15 years have done and what work has come out of that. And I actually think that this is going to be a very encouraging project. It is not my goal, and it is not my anticipation that we'll come up empty-handed. I think we'll see that there are tons of resources out there, tons of people, tons of programs that are doing excellent work, and we should be funneling money into those programs, utilizing our power here at the legislature to support those programs, analyzing the policies that have been successful and unsuccessful, and sharing that information across different jurisdictions within Nevada so that every corner of Nevada can have the best possible response to human trafficking. And so that is what Section 4 is designed to do. And the third piece of the bill is contained in the amendment, and you should have a mock-up of it. In section, it's at the very end, in section 7.4, this bill challenges the legislature to put our money where our mouth is and allocate $1 million to the from the state general fund to the contingency account for victims of human trafficking. That fund is administered by the Department of Health and Human Services. I talked to them this morning. They have a grant system that they utilize to take requests from agencies or nonprofit organizations in the state that are combating human trafficking, and they have to meet certain criteria that DHHS has already set out. We do not have to reinvent the wheel here. This fund already exists with an application process with requirements that an organization has to meet in order to be eligible for this funding. And the DHHS has a process through which they award grant funding from the contingency account for victims of human trafficking to nonprofit and governmental organizations throughout the state of Nevada that are doing the good work that we've been asking them to do for the last 15 years. And so I'm hopeful that we will be able to get this appropriation approved in order to ensure that all of those organizations who are bringing to the table in the interim also have the resources necessary to carry out the good work they do combating human trafficking. And with that, I'd like to turn it over to my co-presenter to talk a little bit more about that missing enforcement piece that we seek to correct in SB 389.
Thank you, Madam Vice Chair. You ready? For the record, Senator Heidi Seifert-Scansard. I appreciate working with Senator Scheibel on this important legislation. And she mentioned some of the statutes that we're looking to change, and particularly in Section 2. So back in around 2007, I worked with now U.S. Senator Catherine Cortez Masto on similar legislation, but it was online luring. So law enforcement or representatives of law enforcement were trying to make sure that folks who believed that they were luring children, who confirmed that they were luring children, were prosecuted as if they were luring children. This is a similar bill. So if you have someone who is trying to traffic or solicit someone who they believe is underage, they should be prosecuted as if that person is underage, and those penalties are steeper. So Section 2 is about making sure those who are trying to solicit someone who they believe to be a minor, whether that is law enforcement or someone who is representing law enforcement, that they're prosecuted with the statutes related to minors. Another change that is in this bill is on Section 5, I think was the money. There is an account right now, the Victims of Crime account, that is under the Attorney General's office. And right now, victims of sex trafficking can only apply for 24 months. And it's in Section 5. This is moving it to 60 months. What we found is individuals who are victims of sex trafficking, it takes a while for them to recover, it takes a while for them to understand the needs that they may have, and this fund is specifically set up for victims of crime, and it can help with housing, with childcare, with relocation, a variety of different things, and they need more time to be able to access those funds because it takes them a while to realize that they want to get out of that life and make an application for those types of funds. And I believe that Senator Scheibel covered the reporting requirement and also the ask for the $1 million to put into the contingency account, which, as she mentioned, already exists. It's not a new account. It already exists in statute. Thank you.
I forgot one more thing. There's also a conceptual amendment available on Nellis. I received it while I was sitting on the dais from the Attorney General's office. It's very simple. It changes in the statute that makes it illegal to solicit a child for sex. The wording there to be consistent with the wording here to include a child or an adult posing as a child to basically close up that same enforcement gap.
All right, committee members, questions on Senate Bill 389? Okay, we'll go ahead and open it up for testimony in support of Senate Bill 389. If you are here in Carson City and you'd like to testify in support, come on up.
My name's Ernie Adler. I represent the Embracing Project, which is a group of women that are trying to combat sex trafficking by helping the victims of sex trafficking. What it is essentially a drop-in center in Las Vegas, which provides material resources, empowerment support, adult education program, mentoring programs, parenting programs, financial literacy training, employment readiness, counseling, and trauma-informed care for women who are being sex trafficked. And they have a caseload of about 100 girls or women in their program. One of their chief problems currently is that they are losing a grant which paid for housing, for supportive housing for sex trafficked victims. And what this bill does essentially is, with this amendment, allows them to be able to apply to the state for additional funding to keep their supportive housing open for these women, which is of critical importance. So with that, I'd say I strongly urge you to vote for SB 389 because I think it's a very important bill for being able to solve the overall problem of these victims of sex trafficking.
Good afternoon, members of the committee. Reagan Comas with R&R Partners here today representing Awaken. And I'd like to thank Senator Scheibel and Senators Gansert for bringing this legislation forward. While we are in support of the entirety of the bill, and I think increased reporting is important for us to be able to analyze what's happening in this state, I'd like to really focus my testimony on Section 5 in particular. As noted, victims of sex trafficking have extreme trauma that has happened over a long period of time, so it takes it longer for them to be able to even recognize that they are victims in many situations. And so, in particular, we had one survivor that had needed some dental care but wasn't able to get it because when she applied, it was 2 months after the 2-year deadline. And so I think expanding that time frame is appropriate, and like many other nonprofits, being able to access funding is always a challenge, and so we are in support of that extended funding for the contingency fund. Thank you.
Vice Chair Harris and the Senate Committee on Judiciary. My name is Chris Reese, it's R-I-E-S, and I represent the Las Vegas Metropolitan Police Department. We support SB 389, and I just want to be brief and thank Senator Scheibel and Senator Sievers-Gansert and their dedicated efforts to protect our vulnerable children and victims. Thank you.
Good afternoon, Vice Chair Harris and members of the committee. My name is Jennifer Noble on behalf of the Nevada District Attorneys Association. We are in support of Senate Bill 389 and its conceptual amendment, and we thank Senator Scheibel and Senator Gansert for their efforts to ensure that Nevada not only works to combat sex trafficking, but does so in a trauma-informed, efficient, and common-sense manner. Thank you.
Good afternoon, Senator Harris, members of the committee. Jason Walker, Washington County Sheriff's Office. It's a good bill. Testifying to support Senate Bill 389.
Okay, we don't have Las Vegas anymore, so let's just go to the phones. BPS, anyone to testify in support?
If you'd like to testify in support of SB 389, please press star 9 to take your place in the queue.
Thank you to the chair and thank you to the bill sponsors. For the record, my name is Michael Willoughby, W-I-L-L-O-U-G-H-B-Y, calling today as part of Alfaro Consulting. We're here to support this bill. The best time to pass this bill would have been 10 years ago, so the second best time to get this bill moving to help these victims and to help these nonprofits giving aid is today, and I would encourage this committee to do so. Thank you very much.
Hello, my name is William Ledford, L-E-D-F-O-R-D. I'm the Director of Advocacy for Lutheran Engagement and Advocacy in Nevada. Our organization has a long history supporting bills related to dealing with the issue of sex trafficking in our state. And so we appreciate the wisdom of doing an audit on the work that we've been done and trying to see the results of that work, as well as the money going to the organizations that are aiding victims. So this is a fantastic bill, and we have very strong support of it. Thank you.
There are no further calls testifying in support.
Okay, anyone here in Carson who'd like to testify in opposition to Senate Bill 389? All right, BPS, will you please check the phones for opposition, please?
If you would like to testify in opposition of SB 389, please press star 9 to take your place in the queue. There are no callers testifying in opposition at this time.
Okay, we'll go to neutral testimony. Anyone here testify in the neutral? All right, BPS, phone lines for neutral, please.
If you would like to testify in neutral for SB 389, please press star 9 to take your place in the queue. are no callers testifying in neutral.
Okay, unless you want to make closing comments, great. We'll go ahead and close out the hearing on Senate Bill 389 and open the hearing on Senate Bill 415.
All right. Melanie Scheibel, for the record, State Senator from District 9. Thank you for having me today to present Senate Bill 415. I am joined by John Pirro and Jennifer Fraser to co-present with me, and Bridget Duffy has been kind enough to anticipate your questions for her and come up to the table and to answer them. But briefly, I'll just kind of explain to you where SB 415 came from and what it's supposed to do. I served as the chair of the Interim Judiciary Committee, and in the Interim Judiciary Committee, we heard a lot of presentations from a lot of different folks, and we had a day dedicated to juvenile justice, which I think was very productive, and we learned a lot about the juvenile justice system, and we all put our heads together to think about ways that we could improve it, as we do throughout the interim and every session. One of the issues that arose in our Interim Judiciary Committee was the fact that when we passed AB 236 in the 2019 session, we created for adults a system where when they are put on probation for any particular crime, they have they know when they'll be off probation. We put in time limits on how long a person could be put on probation. We didn't do the same thing for juveniles, which made sense because AB 236 wasn't a juvenile justice bill. It pertained to adults. But at the interim, we got to have that conversation about, how can we do more in the juvenile justice system to address those evidence-based practices and that data-driven crime reduction policy that we addressed for adults in AB 236. And one of the suggestions was to ensure that juveniles, just like adults, have some kind of certainty when they're put on probation about how long they will serve that probationary period. And so at the end of our Interim Judiciary Committee meetings, the committee voted. This was one of several recommendations for juvenile justice and other kinds of justice, and one of them was to create that parity for adults and juveniles to ensure that juveniles have a fixed probationary period, and the committee voted to approve that recommendation, and that is how we got to Senate Bill 415, which has evolved to not just provide that probationary period certainty, but also through the hard work of numerous stakeholders. You have an amendment in front of you that ensures that we utilize this opportunity to do a lot of good work and use, again, those evidence-based practices, utilizing reports created pursuant to 62E.506 when we're talking about adjudicating juvenile cases, or adjudicating is probably not the right word, handling juvenile cases, and when we're talking about ensuring that the probationary period is productive and serves its purpose to rehabilitate a juvenile. And so that's kind of an overview and a background of the bill. I'll hand it over to Mr. Pirro and Ms. Fraser to give you a little bit more context.
John Pirro for the record. I'm going to kick it to our subject matter expert, Ms. Fraser, to talk about how kind of increased sanctions do not necessarily reduce recidivism. And this bill, with the amendments, goes a long way towards providing equity and due process for our children.
Thank you, Chair Scheibel, for presenting this and allowing me to co-present, and thank you, committee. I think this is a very important bill. As described, it does fix a huge gap that's in the statute with regard to probation terms for our youth in Nevada. There is a current statute, 62B 410, which indicates that the juvenile court can have jurisdiction until age 21. So what that means is when a child is placed on probation at any age, 10, 11, 12, and up, for any offense in the juvenile system, the court can order them on probation until their 21st birthday, or the court could just place them on probation, which happens in many jurisdictions within our state. I've talked with some colleagues in Washoe County as well as Carson City. They're just placed on probation. There's no fixed term. And essentially the attorneys have to explain to the child and his family kind of a guesstimate of maybe when you'll get off probation. And as we know with adolescent brain science, our kids need incentives and they need short-term goals. So an indefinite term up until age 21 or until who knows when is not serving our youth, and it isn't serving our community either. Longer probation terms are not more effective than shorter terms in preventing future offending behaviors, and it can actually increase the likelihood of revocation, which means incarceration for our youth. And that disconnects our youth from important, critical community-based support systems and interferes with their pro-social development. Even I recognize, I think we all do, the stakeholders in juvenile court, that the intent of juvenile court is a rehabilitative court. It's focused on treatment. But even with that intent, putting indeterminate probation terms on our kids puts our youth at risk of further entrenchment in the system. So I think this bill is the perfect fix. You'll notice a difference between this bill and the adult probation terms. Those are offense-based. For example, if you are convicted of a gross misdemeanor, you can get up to a certain amount of time, or certain category A, B, C felonies would mean certain amounts of time. That's different because we recognize kids are different. Juvenile court isn't just a mini criminal system, but we look at the whole, like the holistic picture, the whole child, what risks and also what needs need to be responded to. So that's why the amendment includes looking at the 62E reports, the risk assessments, other information that probation has. So it's about the child, not just the offense. And I think that's critically important as well. And I thank you for your consideration.
Okay, committee members, do we have questions for Senate Bill 415? Must be a deadline day around the corner. Okay. We'll go ahead and open it up for testimony and support then. Anyone here in Carson City to... Oh, I'm sorry, Ms. Duffy, go ahead.
Thank you, Vice Chair Harris. Bridget Duffy for the record. I am putting on our support and thank you for the stakeholders from working with us and Senator Scheibel for putting us all together to come up with this proposed amendment, which I believe will serve our system well. And I'm putting that support on behalf of the Nevada District Attorneys Association, and I was also asked to put on the support of the Department of Juvenile Justice Services for Clark County, as I'm a registered lobbyist for both. Thank you.
And then John Pirro from the Clark County Public Defender's Office, we support.
Good afternoon, Vice Chair. Erica Roth on behalf of the Washoe County Public Defender's Office, testifying in support. Thank you.
Okay, do we have, BPS, anyone on the line who'd like to testify in support of Senate Bill 415?
If you would like to testify in support of Senate Bill 415, please press star 9 to take your place in the queue.
Tanya Brown, TONJA, BROWN, Advocates for the Inmates and the Innocent. We support this bill. Thank you.
There are no further callers to testify in support.
Okay, anyone in opposition to Senate Bill 415? Not seeing any. BPS, can we go to the phones, please, for opposition to Senate Bill 415?
If you would like to testify in opposition of Senate Bill 415, please press star 9 to take your place in the queue. We have no callers in opposition.
Anyone here in Carson City for neutral testimony on Senate Bill 415? All right, not seeing any. BPS, can we do it one more time?
If you would like to testify in the neutral for SB 415, please press star 9 to take your place in the queue. We have no callers to testify in the neutral.
Okay, we will go ahead and close out the hearing then on Senate Bill 415 unless the sponsor would like to make any closing comments. Okay, we'll close the hearing on Senate Bill 415 and I will turn the gavel back over to the chair.
Thank you. All right, let's do some public comment. Anybody here for public comment? No one rushing to the table. Let's go to the phone lines for any public comment.
If you would like to provide public comment, please press star 9 to take your place in the queue.
Tanya Brown, TONJA, Advocates for the Inmates. We would like to thank Chair Scheibel and the members of the Senate Judiciary for passing some of these long overdue bills. We truly and truly appreciate them, what the great work you've done. As I spoke yesterday, I'm going to touch on it again today. Assembly Bill 49 is going to be coming your way, and we are asking that you support our proposed amendment to establish a factual innocence posthumous petition. And hopefully the Judiciary Committee or a member will sponsor our proposed amendment. I just kind of want to just touch on a couple of things. As a reminder, eyewitness is the #1 leading cause of a wrongful conviction. And if it hadn't have been for the Innocence Projects throughout the country, thousands of inmates who have been wrongfully convicted would still be behind bars. Some would have died while incarcerated. And thankfully, we do have this as a remedy for some people, but then there are some that will never see the light of day because either the DNA doesn't exist or for whatever reasons they cannot take these cases. But I want to touch on something that's never been really touched on before, and that is what we don't normally hear is about a perpetrator of a crime who will correct an injustice that has been done to someone else due to their own bad acts. And I'm just going to briefly touch on such a case. Excuse me. Took place about 33 years ago in California, 1990. And anyways, a woman was shot. She was murdered. The police contacted witnesses, and it turns out they had one eyewitness. She informed them that she didn't know them. She never recognized them before. And anyways, 2 weeks later, they showed her a police spreadsheet lineup, and she was able to pick out the shooter. Ultimately, she identified one of her neighbors as the shooter. And then he was convicted 20 years later through the help of the Innocence Project. They were able to locate the real perpetrator of the crime, and this is where Nevada comes into play. This perpetrator of the crime is a Nevada inmate. And through him and the Innocence Project, he gave a declaration for this innocent person. He confessed that he was the shooter of the woman in California. And based on the declaration by this Nevada inmate, the inmate, after 20 years, was finally exonerated in 2010. Although this is rare, but we really don't know what will happen in the future as these perpetrators of these crimes somehow get a conscience and decide to do the right thing. And if they do the right thing and the person is dead, there's no exoneration for them. We ask that you support our AB 49 proposed amendment. And thank you. And again, thank you so much for the great work you've done.
Anne Marie Grant, advocate for the inmates and the innocent. Eyewitness identification is the #1 leading cause for a wrongful conviction. I want you to take a look across the street at the Bank Saloon when you leave the building today. Prior to it becoming the Bank Saloon, it used to be Jack's Bar for decades. It is also Tanya Brown's brother's alibi for the May 9th, 1988 crime in which Mr. Klein was wrongfully convicted of committing. Mr. Klein had 5 alibi witnesses placing him in Jack's Bar hours before, during, and after the crime was being committed in Sparks, 30 miles away. The description of the suspect given by the victims in this crime did not even come close to matching Mr. Klein. However, 2 weeks after the crime occurred, Mr. Klein walked past the shoe store in Sparks, and one of the victims said he looks like the guy, and based on that, Mr. Klein was picked up, detained for hours without Miranda. A photo was taken of him in which was used to put him in a tainted photo lineup array. And today, that photo lineup array that was used in order to get a positive ID by the victim is no longer used by law enforcement agencies because it is the type of photo lineup array that has led to wrongful convictions. These 5 witnesses stand by their testimony that they were there with Mr. Klein during the entire night, and yet he got convicted. We understand that 20, 30, 40 years ago, people, particularly juries, believed that the victim would never forget what their attacker looked like. But we know now that this is wrong. We ask that you support and possibly sponsor our proposed amendment to AB 49 to allow a petition to establish factual innocence posthumously to be heard. It should be noted that one of those witnesses who testified and placed Mr. Klein at Jack's Bar with him the night of the crime would later go on to become a law enforcement officer with the Carson City Sheriff's Office. And after 20 years, he would retire as a sergeant. And he still stands by his testimony to this day that Mr. Klein was with them as a group when this crime was committed. Again, please support our amendment to AB 49. Thank you.
That concludes callers for public comment.
All right, thank you so much. With that, we are done for today. We are scheduled to start tomorrow at noon, and we will see you sometime tomorrow. We are adjourned.